She's got a folder full of names, each one set to take the blame. She don't argue, she don't explain. Subpoena Smollett strikes again. Oh, Subpoena Smollett, she's got papers to serve. Oh, Subpoena Smollett, your tweets hit a nerve. Lawyers running down the aisles, Costco carts stacked up for miles, buying subpoenas invoke no smiles, her critics silenced in legal piles. Oh, Subpoena Smollett, better watch what you say. Oh, Subpoena Smollett, she'll sue your memes away. Lawyers running down the aisles, Costco carts stacked up for miles, buying subpoenas in bulk, no smiles, her critics silenced in legal piles. Oh, Subpoena Smollett, better watch what you say. Oh, Subpoena Smollett, she'll sue your memes away. She don't care for your free speech. One bad post and you're in reach. You think you're clever, think you're free. Her legal team will disagree. Oh, Subpoena Smollett, better tread real light. Oh, Subpoena Smollett, she's up late tonight.
Hello. Yay, we won. I mean, we haven't won yet, but justice, I mean, it was a great day in court today with Judge Lyman basically telling Lively, like, girl, get lost. She has three claims remaining, and it was just, I think it came to a surprise for many of us because this happened I wanna say moments before the scheduled hearing, and actually, let me share this. I need to share this tab. Sorry that I wasn't entirely prepared, but I was so excited. I think this was the only time I could go on. Hold on one sec. Let me get my slides for you guys. I mean, how are you guys excited? Are you still in shock? Do you believe it? Okay. I'm just gonna share this really quick. Okay. So, again, Wade Parabaldoni prevails. Only 3 claims survive for Lively, and even those are sort of a joke. And so today there was supposed to be that hearing, and actually, let me get to that slide, and it was right before it dropped. I was thinking back, yeah, because everything came so crazy, but right before it dropped, or right before the hearing started, this order dropped, and I was like, "How did this happen?" And remember Khaleesi, she's not here right now, one of our mods, but we have the beautiful Laura and Christina are here. Thank you guys so much for being here because I know you've been busy all day. But Khaleesi had said, tomorrow's a pink full moon, and I was like, I don't know what that means. Well, maybe it means that something about justice, because it was like the first time in this entire case that I feel like has gone on for so long that we've even had any sense of like justice. It would her Blake Lively, and this is all my opinion, in my opinion, but I think her claims were totally bogus this whole time. I think she made a mockery of the judicial system. I think she's a joke. I think that she put these people through hell basically because she had the money to do so. And I think that this judge kind of let her do whatever she wanted. And then finally it got to the point where it's just like, there's nothing there. Like even this judge who's done everything for her is like, we can't do anything for you. And I just love watching MSN mainstream media kind of like fall over themselves, having to report this. And they're trying to say, oh, is the judge that dismissed it? Oh, is a technicality? No. He dismissed it because it's BS. And we're gonna read this People article in a second because it gives his reaction. But maybe for these people, I should explain it to them why her SH claims were dismissed. I have a video to explain it if you're not sick of my songs yet. Because, it's not playing. 1 second. Oh, it was blank. This is why it was dismissed. Darn it. Here we go.
Wanted to remove the director for harassment, but then keep him on as the actor. Major red flag, this was a power grab. There is no escaping the truth. You can't trust in a predator, get right rid of him. That is actual malice written in ink on you. Major red flag, this was a power grab. There is no escaping the truth.
So you don't have to listen to the whole thing. But my point is that they wanted to remove him as the actor, but not as the director, not in any other capacity, not like remove him from the set, nothing. They wanted to just remove him from the actor role. Or sorry, they wanted to leave him as the actor. I said that backwards. Sorry, I'm really tired. They wanted to remove him as the director because it was a power grab. They wanted to remove him as the director, but not the actor. I mean, so you're saying there's SH, you're saying he's this big bad guy, and you want to file all these claims, but it's okay if he stays on as the actor. Let's just remove him as the director so that she can get her PGA or whatever the hell it is. So anyways, I mean, it's pretty simple, right? And I don't know, but she really had nothing. And it got to the point, this is kind of where this case made me sick. Like, I honestly, of course, I'm going to report on it till the end. But when Lively's team demanded Jamie Heath's wife's her birth video, that made, and then the judge allowed it, that kind of like, it made me sick of this case. And I was like, as someone who I enjoy the legal system, I like seeing justice. It would like actually like hurt my heart and it hurt my gut to see when he made that, when that happened, because I thought it was such BS. And I was like, so you're saying that someone who's a non-party to this case, her birthing video is going to be your only claim left for SH? You're going to say that because he showed you a second, that you can't remember what happened during it because you can't even get a description of it, but that's going to be your SH? Shall we rewind the tape for those that don't know? For all these like people that are reporting that as a technicality, it was a birthing video. That was going to be her claim. Let me share this instead. Let's talk about Pumpgate. Why are we still here? Why? Oh, that's the wrong one. Hold on. Uh-oh, DFJ did not put the right clip. Well, anyways, Pumpgate, she basically asked for the birthing video and he said yes, and it was really disgusting. And then it turns out that Baldoni actually gifted her a garment to cover up her milk jugs. Oh, and by the way, Kinney has a Milk Jugs song that you guys should check out. That's really good about this case. That was one great thing that happened as a result of this case. Oh, here we go. I got the clip for you. Why are we still here? Why are we? It's not the clip. I don't know why it keeps going to this one. Oh, because it's doing something else here. I see it. A prototype that originated with his mother. We're getting into Pumpgate now. Baldoni's wife co-founded a company that designed a breastfeeding garment, a prototype that originated with his mother when he was an infant. Baldoni had gifted Lively one. Lively is saying that they came into her trailer, it made her uncomfortable. They were trying to come see her milk jugs while she was pumping. Then they pulled up the receipts that were like, girl, you invited us in and you said to come in while you're pumping. It was the only time you'd actually work on the lines with us. It was almost like she was entrapping them. Like, come in while my tits are out and I'm pumping. And so they looked her in the eyes and she's like, well, don't look me in the eyes or I'm going to say it makes me uncomfortable and claim SH. But it wasn't even like that. Baldoni gifted her a garment to cover her boobs while she was pumping. So we're getting into Pumpgate now. This was not a technicality. This was because her claims were bogus, because everything about her claims was a joke. And I've seen some I see some of our favorite people here. We have Vague here, Lori's here. They're driving. A lot of people are driving and listening. And so, sorry, this was a little bit chaotic. I threw this together last minute just because I wanted to see you all and celebrate with you all. I saw some of you earlier on CJ's, and like I said, there was supposed to be a, let me get to the slides. There was supposed to be the hearing today, which we couldn't hear anything. It was pretty useless. And just right before, and I was on live with her, and right before we went live, this order and opinion dropped. And it was 152 pages. I might, towards the end of this, start reading some of it if any of you are interested in that I think Lauren's going to go on later with the Tilted Lawyer. I think in like 2 hours she's going on. But here, let's get back to the slides here. Because I want to show, okay, and basically, we didn't really get to hear the hearing because the hearing, it was just like technical difficulties. And I made a joke for any of those who were on my stream last night, we learned about that judge who was really rude to the IT guy. And I made a X post today. I was like, the SDNY court should hire that IT guy that from Texas, from Harris County. I feel like they could use someone like him to help with their technical difficulties, because for whatever reason, they can never have a hearing where we can actually hear anything. It just sounded like garbledness today. And JC says, sorry, I read up to page 70, got bored. Good. I cannot wait to read the whole thing. Oh my gosh. Hi, Mia. Hi, everyone. Kenny, Kenny, you said something so interesting. I want to go back to this because, yesterday when we found out about the pink moon, and I asked Kenny, what does that mean? And you said key themes of moon: releasing negative energy, correction, and clarity. I mean, that actually does sound pretty perfect, right? Amazing. Absolutely amazing. Kenny, question, what's the definition of bravery? Sorry if I missed what you had said before that. Okay, so, and then Kenny says, I needed some good news. Shitty morning and Uncle Pass, so thank God for some good news saying before you feel bad, I'm okay just saying I couldn't have handled the bad news. Well, we're so glad to have you here, and I'm so sorry for your loss. So sorry. I'm just glad, I hope that this can help you. Maybe that you have a chat family. We all love you and we're all here. And, I look at Wayfair, they've been going through a different sort of loss, like a hell, for the past year. Like they had their reputations dragged through the mud. Steve Sarowitz literally had his family was threatened. Like there was arson done on his yard. They threatened to kidnap his daughter. And all of this, that was after a Forbes article that was, another thing that Lively threw out there. Like Lively, in my opinion, went out of her way to try to destroy these people and take away everything from them. And so now today they get to heal. And so let's read that People article because we are so out of order. I threw these slides together last minute because I actually ended up having to leave CJ's live because I had another meeting today. But let's go ahead and read. I don't know if you guys have seen this one yet. I don't know why they do all these ads on this. Hold on a second. Okay, so this is from People. Justin Baldoni. Let me make sure you can see it. Yeah. Okay. Justin Baldoni reacts to dismissal of Blake Lively's SH claims against him. What's left is a significantly narrowed case. And it says, we look forward to presenting our defense to the remaining claims in court, Baldoni's legal team said. And he said, okay, they do it all weird like this. They give you recaps for people who can't read the whole full article. Justin Baldoni is responding to the recent shakeup in his legal battle with Blake Lively. Judge Louis J. Lyman, a federal judge in the Southern District of New York, ruled on Thursday, April 2nd, on Baldoni's bid to end the case involving It Ends With Us co-star, dismissing 10 of her 13 claims against him. We're very pleased the court dismissed all SH claims and every claim brought against the individual defendants: Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel. Alexandra Shapiro and Jonathan Bach of Shapiro Arado Bach said in a statement shared with People. These were very serious allegations, and we are grateful to the court for its careful review of the facts, law, and voluminous evidence that was provided, the statement concluded. What's left is a significantly narrowed case, and we look forward to presenting our defense to the remaining claims in court. See? So this doesn't sound like they're settling to me, but I don't know what you guys think. It says 10 of the 13 Oh, shoot. Hold on one second. It says 10 of the 13 claims Lively, 38, filed against Baldoni, 42, following their behind-the-scenes conflict on the 2024 Colleen Hoover adaptation It Ends With Us, were thrown out in Judge Lyman's latest decision. These dismissed claims included those related to harassment, defamation, and conspiracy. Lively's breach of contract claim and a FEHA retaliation claim against Baldoni's company Wayfair Studios will still move forward to trial. The two co-stars' conflict began in December 2024. Oh my gosh, why does it do this every time I highlight? Sorry, you guys. When the Gossip Girl actress filed a SH complaint against Baldoni alleging misconduct on the set of the romantic drama and a retaliatory smear campaign. The director's star, who has denied the allegations, filed counterclaims against Lively and her husband, Ryan Reynolds, involving allegations of extortion and defamation that were dismissed by Judge Lyman in June 2025. Baldoni's legal team opted out of refiling amended versions of those claims. Oh, and then remember, this is Justin and his wife was Emily, and this was in February at one of the hearings, and like they were dressed so beautifully. And then you had Blake Lively show up when it looks like Ryan Reynolds' laundry or something. Good thing they don't have that photo in here. Sigrid McCauley, oh God, a member of Lively's legal team. Remember her? People said she looked like Kristen Wiig, and she was standing outside the court and gave that like off-the-wall statement. Sigrid McCauley, a member of Blake Lively's legal team, also reacted to the April 2nd ruling, pointing out in a statement shared with People that the actress's SH claim against Baldoni isn't going forward, not because the defendants did nothing wrong, but because the court determined Blake Lively was an independent contractor, not an employee. Who wants to tell her? Who wants to tell her she's wrong? I mean, she has to know she's wrong, right? Lyman's new ruling follows a February 11th court-mandated settlement conference with Baldoni and Lively each ended without an agreement. Attorneys for both actors have stated that they plan to testify during the trial, scheduled to begin May 18th in New York. You guys, what are your thoughts? I mean, this is pretty exciting if you ask me. I'm excited. Let me go. There was something I wanted to read here for you. Oh yeah, this one. But before, oops, one second. Before we do that, though, I just want to get your guys' reactions and see how the poll is doing. Okay, so you said, sorry, I just missed. Someone said, what happened in the hearing? Michelle says, yes, Lauren and Omar at 11:30 p.m. Eastern, which means more like midnight. Oh, why are they normally late? Well, don't worry. I don't plan on going on that long. I really just wanted to see all of you. I miss all of you so much. Look at Jungle Vet Jill. How are you? It says the I am not a cat guy is the funniest. It kills me. Oh, yeah, that's what the technical difficulties always remind me of in that court where the lawyer says, I'm not a cat, judge, because he couldn't get the filter off his Zoom that his grandson put on or whatever. She couldn't take Steve Sarowitz billions. Yeah, I guess she couldn't. And someone else said, so what happened in the hearing? So let me get to that. I actually have that for you guys. Jungle Vet Jill says a lot of MSM is saying he agreed with her, but New Jersey jurisdiction, clear win. Okay. Vague says, I'll be asleep by then. Hopefully we will have gotten to my hotel by then. All of y'all that are driving, please drive safely. And safe travels. And so, you know, I don't think I'm not going to go until she goes on. Like I was probably going to, you know, maybe just go for an hour or something. But I'll definitely link her in here so that you have the link for later if you want. So what went on in the hearing? Let's go to that document. So I have it right here. And let me put me down here. Okay. Make it bigger for you guys. So this says that the court held a status conference in the matter today, April 2nd, 2026. The court discussed certain scheduling matters. As indicated on the record at the conference, the final pretrial conference will be held on April 28th, 2026 at 10 a.m. Eastern in courtroom 15C of the 500 Pearl Street Courthouse. If the agency group PR LLC renews its motion for summary judgment, any such motion shall be filed with the parties' pretrial filings on April 10th, 2026. So it's in 8 days. Plaintiff's response shall be due at the same time as oppositions to motions in limine on April 17th, 2026. The court clarifies that the deadline to file oppositions to Daubert motions is April 24th, 2026. The court otherwise adheres to the deadline set forth as proposed deadlines in the Wayfair's Parties letter of March 25th, 2026, see docket number 1264, and ordered by the court on March 26, 2026, see docket number 1265, so ordered. So basically, I'm not sure if this means the final pretrial conference will be, I'm not sure if that's going to be a public hearing or just a private conference. Either way, I'd mark my calendar for April 28th at 10 a.m. Eastern, just in case, because at a minimum, you know who's going to be there is Inner City Press, right? So maybe I should screenshot this and make sure I ask him. I think that if it's not private, like he'll be there, you know? So that's, I guess, but if you want to know what it sounded like to the rest of us who were trying to listen, it was just like blah, 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 blah. You couldn't hear anything. And the stenographer was speaking into her little thing and that mic kept getting picked up. So it just sounded like a male's voice and a female voice and just like a bunch of garbling. So anyways, let me get back to these slides here. Sorry, one second. Okay. I'm just so excited. I love it when justice prevails. So we read that one. We talked about the SH. We can talk about this the memorandum and opinion. I just wanted, let me see how the poll's doing. I have to go, I think I have to do it this way. How do I pull up the poll on this? Okay, so right now, what it says is that you guys, I said, will Blake and Wayfair settle? 77% say no and 23 say yes. So, I mean, to me, I don't know what you guys think, but like, it's more like Lively is the one at this point who has more incentive, I think, to settle. But I don't know if Wayfair will. I mean, they've gone this far. If, you know, I don't know. Maybe they do want to take it all the way to court. Maybe they want to be like, you put us through hell. I mean, they're not very vindictive people at all. The whole like Baha'i faith and everything and the way they've handled everything. It's really crazy when you think about it, because these people are so measured. They had their cell phones, like all of their cell phones, private emails, private group chats, all of this has been just like totally, in my opinion, inappropriately used in this case. Things that had nothing to do with her claims, in my opinion, and they couldn't find anything. They had thousands of pages. If someone subpoenaed my text messages, I'd probably look like a psycho. Like, you know, like they are so measured in everything they say. They're just so they're always like so kind and just so like, you know, they were so excited to get their truth out there. They never wanted to like put her in a negative light. Like they kept trying to do the right thing, thinking like maybe that she was like somewhat human and not a sociopath, and maybe she would do the right thing, and she never did. And yet they still, you know, stuck to their truth and they stuck together. And I don't know. I still think that maybe they would try to get their truth out, only because maybe I feel like they're in a very special position where they had the funds to fight back. Because I feel like that possibly Lively and sorry, I forgot that like dork's name she's married to, Ryan Reynolds. I thought that Lively and Reynolds have probably done this to many people who could not fight back, or like did not have the means to fight back. They were scared of getting blacklisted. And then here we are, they had the funds to fight back. And I feel like they did it for themselves, but I hope that they at least realize that they probably did it for a lot of other people too. In my opinion, it's just all allegedly in my opinion. I'm going to end the poll here because I think that it seems pretty much stagnant. Okay, so again, yeah, we had 74 no, so that you guys don't think they're going to settle. Well, let's go to court, y'all. Who wants to go to New York in May? Okay, so let me get to, I'm just closing some of these tabs that we've been over, and I'm getting back to this. What did I have on that one? I don't know. This was put together so last minute. Oh, so before I go and read part of this order and whatnot, I wanted to show you guys something that I'm so excited about. And some of you already know this, but for those that don't, let me share this. Yours truly has been blocked by Jonesworks. So I just want, I'm really excited and I wear it as a badge of honor because I wonder like what it was that got her to block me. But just a reminder that we still have that docket that's still open, and that case is bonkers. And I cover a lot of that on my channel. One of my first videos was about what I think, like why I think this was all like how she started it. I think what she did to Jennifer Abel was insane. I think like taking her phone and hijacking it and not giving it back was insane in my opinion. And just the fact that like she basically, what's the right word, you guys? Barbara Streisand herself. I mean, she's a PR expert and she decided to, I don't know, have Blake Lively fight for her, but then she joins in on this fight. Why? I don't know. Why was she suing Wayfair for like the websites that allegedly her former employees put up called StephanieJonesLeaks.com, StephanieJonesLies.com? I just have questions. I love your name. This person right here. Wednesday the black cat. Oh, that's so cute. You know, I have a black cat, Ozzy. He is, some people have him as a badge, and I have one emoji that is based off him. So let me see what y'all are saying. Jungle Vet Jill says Blake won't settle. She just lost 20 million in legal fees and is ready to spend more because she's because sociopath. I agree with that. Okay, JC says, in my opinion, no settlement, go all the way to trial. Then when Justin and Wayfair parties win, they can then concentrate on going after Stephanie Mother effing Jones. Hashtag Stephanie Jones shoplifts. You guys, it's been a while. Like I feel like I have to kind of like dust off the It Ends With Us files because for a while there, like I was in deep. There was a stream, I think it was CJ. She did an end of year stream, was it? Or like an anniversary stream on this trial. And she did like a Jeopardy that Docket Updates hosted the Jeopardy. And I won. Me and Bohemian Diva won. And at first I was excited. And then I was like, I'm ashamed. Like I know way too much about this case. I need to get a life. And thankfully the case kind of like simmered down after that. Now I'm kind of sad that like I feel like we're never gonna see the real like Taylor Swift messages. I feel like there's things we didn't see that I want to see. Jungle Vigil, haha, DFJ, Stephanie MJ Jones knows who you are and hates you enough to block you. Winning. That's what I figured too. I was like, I'm like just like a tiny little like X account. And so I must have posted the fact that she's reading my stuff. I was like, yay, I feel like a winner. And the fact that she went out of her way to block it. I'm like, okay, so I was saying something right. I was definitely, whatever I was reporting was right in my opinion. Oh, Vague says, I know I keep missing lives. Well, we missed you yesterday, especially when we were talking about the YSL stuff. We always miss you, but this is just a chaotic one because honestly, I had to leave. So we were supposed to listen to the hearing with CJ today, and then I was going to do and I'll put that stream if you missed it in the description, but we were going to do the hearing and then read some of the filings that the hearing was about. And then, then this just dropped like minutes before. We're like, oh my God, it's 152 pages. So we're just like trying to read like so fast, skim through it. And then she had like Omar come on and so then they started talking. Then I had to check out for a meeting. So I've still only read a little bit of it. So I'm gonna probably get into reading some of that as we finish up here for those that want to stay and hear some of it. I know some of people don't like to just hear people reading the document. So, oh, Vig says her husband's driving. I'm not driving and texting for once. Good job. Let me see. Oh, hey, Elsie, how you doing? Oh, okay. Michelle says Friedman won't settle for anything. Well, he's such a badass. I love that he is their lawyer, and I'm glad his claims were dismissed too. I thought that was the stupidest thing I've ever seen. It's like they had to go after him for going on Megyn Kelly's show, and Megyn Kelly, she was the one who was doing all the heavy lifting for like attacking Lively. She had some really good rants. I've clipped them. I put them on my different coverage of this case. Yeah. All right. So I think I hope I didn't miss anyone of your chats in here. JC says that was disgraceful when the judge let Blake have the birth video. And I think that was really, I think like that was probably one of the worst moments of this case. And I was like, everyone needs to know who these people are. That was disgusting. And the fact that her lawyers, she has 2 different law firms representing her, and they both were like, okay, yeah, it's no problem. Let's just do that. I was like, it really was disgusting. Quarter Fate, how are you doing? Okay. If you have any more commentary on that, I'll be checking you. Hey, Gareth, how you doing? I hope you're okay. I know you were in the hospital a few days ago. I'm glad to see you. Very cute. Okay, so let's start reading. Oh, Kenny says, well, if Blake only ever cared about the retaliation, then there should be no settlement, right? That's true. That's very true. And I mean, the amount of money, I am like the amount of money spent on this case, it just it's disgusting. But really, I honestly, I just think that like I feel sorry for them. I think I almost like I feel sorry for Blake and Ryan. Like, what pathetic beings, what a pathetic way. You have all that money, you could do whatever you want. There's so many good causes in the world, or you could just sit with your kids and like, like in the middle of nowhere by a beach thing. Instead, someone said something really funny in CJ's live today. They said everyone at the plantation is crying or something today. Because instead, what is she doing? She's wasting this money in court for these BS claims because she wanted to take over a movie and was told no. It's so stupid. That PGA letter sunk her. That PGA letter is the most pathetic thing I've ever seen. And how is like really her retaliation claims going to work? She never reported anything to herself. She was the head of HR. Just asking questions. All right, you guys want me to read some of this? Anyone want to stick around for that, or have other people been reading it? And what I mean by some of this, hold on, is this right here. Okay. Yes, read it. Anyone? Read it? Okay. Okay. Well, I wanted to make sure. All right, one sec. Grab your drink. I'm going to read it right now. And I just want to say right before we start reading it, because I'm going to have a quick sip of tea, but I have the little Aussie man is right next to me, and he's hanging in there. He's doing well. So I just want to let you guys know. Okay, hold on one second, and then we're going to get right into this. Okay. So I'm starting on page 10 because a lot of the beginning is like an introduction. Okay, and I'm gonna make this as big as I can for you guys. Through their 2 pending motions. Oh, did I unmute myself? Okay, good. Through their 2 pending motions, the Wayfarer party moved for judgment on all claims. Their motions for judgment on the pleadings and summary judgment overlap in many respects. To the extent that they do not, however, the parties dispute whether the court should, in considering the motion for judgment on the pleadings, also consider factual disputes presented in the motion for summary judgment. Lively contends that even if the Wayfarer parties have identified some deficiency in her pleadings, the court should conform the pleadings to the evidence in the summary judgment record and evaluate the Wayfarer parties' arguments on that basis. Docket number 1055 at 3 through 4, the Wayfarer parties respond to that motion for judgment on the pleadings, tests the sufficiency of the pleadings, and that the court therefore must not consider extraneous materials outside the pleadings in its analysis of that motion. A recent Second Circuit decision sheds lights on the issue, and it suggests that Lively has the better of the argument. In Miller versus Lamana, the circuit addressed a situation in which, following extensive discovery, the defendant moved for summary judgment, arguing both that the complaint failed to state a claim and that the summary judgment record did not create a genuine dispute of material fact. In addressing the motion, the district court confined its analysis to the defendant's arguments regarding the sufficiency of the pleadings. The circuit explained that the decision was error. Once discovery has been completed, as here, we do not regard the pleading standard as requiring that the defendant's Rule 12C motion be granted if evidence that has already been produced during discovery would fill the perceived gaps in the complaint. And they're quoting Ideal Steel Supply Corp versus ANSA. It added, even if the allegation in the complaint were insufficiently detailed to survive a motion to dismiss. Had such a motion been made before discovery, if the evidence collected in discovery raised triable issues of fact, it would have been appropriate for the plaintiff to amend his complaint to conform to the evidence thus collected. Dismissing the complaint at that stage when the evidence adduces, whatever, in discovery may have been sufficient to survive a summary judgment motion would hardly serve the efficient or just resolution of disputes which the very foundation of the federal rules. Here, the parties have completed an extensive and fiercely contested discovery process. That's one line that I can agree with from Judge Lyman. The Wayfair party's motion for a judgment on the pleadings came towards the end of that process, and only shortly before its motion for summary judgment. In these circumstances, it would hardly serve the efficient or just resolution of this dispute for the court to limit its analysis solely to the pleadings rather than the entire record on summary judgment. In any event, this dispute ultimately matters very little, and the Wayfair parties have identified only a handful of allegations which they believe should be disregarded in consideration of the motion for judgment on the pleadings. And those allegations are immaterial to any determinations the court reaches. The court starts with Lively's contract claims. It then proceeds to discuss her federal claims, her California statutory claims, and her common law claims. So we're starting 1, contract claims. How are y'all doing? Are you still here? Hello. Okay, people are still here. Okay, cool. We'll keep going. Contract claims. Lively brings contract claims against It Ends With Us movie and Wayfair for the purported breach of 2 agreements referred to as the Actor-Loan-Out Agreement, ALA, and the Contract Writer Agreement. Her 8th cause of action alleges a breach of the ALA, and her 9th cause of action alleges a breach of the CRA. Lively grounds her claims in 2 provisions of the agreement. Paragraph 7 of the ALA, which prohibits SH and retaliation, and paragraph 10 of the CRA, which prohibits retaliation against Lively for raising concerns about the misconduct on the set of the film. It Ends With Us movie and Wayfair respond principally that the agreements are non-binding and unenforceable. They argue in the alternative that even if the agreements are enforceable, there was neither a breach nor cognizable damages. The court recounts the facts relevant to these claims before analyzing the merits of the parties' respective elements. Factual background. And actually, right before we get to this factual background, I do have a chart I can show you that, let me see how I can pull this up. I'll make sure I screenshotted it. Yeah, I did. Okay, so let me see if I can just pull this up. It's actually from NAG. If you don't know her channel, Not Actually Golden, which I actually think probably here everyone knows. And I just think, just so you can see this before we keep reading, I want you, oh, it's not going to let me make it bigger. Can you guys sort of see that? I'm so sorry it's small. But basically, so she puts Lively's claims in order and then shows like what's out and what's in. So it's like the FEHA retaliation is in, the FEHA aiding and abetting and retaliation, it says out is Abel and Nathan, but tag is still in. But whatever. And then breach of writer, and that's still in. So like all these other ones, breach of loan out, California, the false light, the California Civil Code SH, the defamation, civil conspiracy, FEHA SH, Title 7 retaliation, Title 7 SH. I mean, those are all gone. That's just so funny. In my opinion, I'm glad. So let me remove that and we'll go back to this. Okay. And sorry, let me just put myself back on the bottom. All right. Factual background. Formal negotiations regarding Lively's appearance in the film commenced in mid-December 2022 when Emin Mezzanine, Wayfair's vice president of business legal affairs, sent Lively's representatives a draft offer letter. Following additional negotiations and exchanges of drafts, the parties circulated a final version of the offer letter on May 4th, 2023. The letter sets forth an agreement between Lively's loan-out entity, Blakely Inc., defined as lender, and It Ends With Us movie, the special purpose entity, Wayfair Incorporated, to develop and produce the film, defined as producer. Blakely, what a stupid name, agreed to furnish Lively, defined as artist, to provide acting services to It Ends With Us movie in the role of Lily Bloom in the film, to be directed by Baldoni. Among other things, the offer letter specifies the timing and location of filming, Lively's compensation, her mutual approval rights over certain aspects of the production, and her credit as an executive producer. It states that Lively agrees to provide exclusive principal photography services for up to 6 consecutive weeks during the run of the production. The offer letter contains no terms regarding SH. Do you guys want me to read this footnote? It just says, a loan-out entity is a duly organized corporation, typically wholly owned by an artist, the sole function of which is to loan out the services of the artist owner to producers and other potential employers. And then it says, it is common in the film industry for a separate entity to be established for each individual film product to separate each production's liabilities, investments, ownership, structure, rights, assignments for distribution, and accounting. The special purpose entity is often necessary for the purpose of obtaining production or post-production tax credits, which are often based on the specific jurisdiction in which individual films are shot or edited, as well as the residency of members, the crew, and for residual reporting with unions such as SAG, AFRA, DGA, and WGA, which determine participation on a project-by-project basis. Okay. Good to know. Speaking of SAG, I'm just curious, or are they gonna revoke her PGA credit? Probably not. But that would just be the icing on the cake, in my opinion. Okay, paragraph 13 of the agreement, titled Conditions Precedent, provides that producers' obligations to artists hereunder shall be subject to the satisfaction of full execution by artist, lender, and producer of an agreement in a form reasonably acceptable to all parties. Shapiro. Declaration. In contemplation of additional negotiations to follow, the offer letter also states that once we reach an agreement on the above terms, we will be happy to distribute a long-form agreement incorporating the terms herein and other standard terms, including without limitations, premieres, publicity, travel expenses, indemnity, insurance, etc., and conditions to be negotiated in good faith. Oh. 4 days later, on May 8th, 2023, Joseph Lanius, outside counsel for It Ends With Us movie, sent Lively's counsel a draft of the ALA, which would serve as the long-form agreement mentioned in the offer letter. As with the offer letter, the draft ALA lists the parties to the agreement as It Ends With Us movies, defined as company, and Blake Gull, defined as lender, with an inducement to be signed by Lively, defined as artist. Wayfair was not made a party or signatory to the draft agreement. The first section of the draft ALA is titled Conditions Precedent, and provides that companies' obligations under this agreement are conditioned upon certain circumstances, including, as relevant here, 1, companies' receipts of executed copies of this agreement signed by lender artist, and 2, companies' receipt of the inducement attached hereto and incorporated herein by this reference, fully executed by lender and artist. Shapiro Declaration. The draft ALA also contains an entire agreement provision incorporating certain standard terms as attached Exhibit A to the agreement, and specifying that the ALA, including the standard terms, constitutes the entire understanding of the parties hereto and replaces any and all former agreements, understandings, and representations relating in any way to the subject matter hereof. The ALA adds that no modification, alteration, or amendment of this agreement shall be valid or binding unless it is in writing and signed by both parties. The standard terms appended to the draft agreement include several provisions relevant for present purposes. So I'm not going to read exactly. I'll just say what they are. It just says companies breach, notices, governing laws, non-waiver, effective termination, entire agreement, severability, lenders and artist remedies. Did we read these whole things before? Limitations and damages. Okay. Paragraph 7 of the standard terms, titled SH, further provides that, we should read this one. SH of any type is strictly prohibited and cause for immediate termination of this agreement by a company. No employee shall be subjected to SH by another employee during the course of employment. For the purposes of this policy, SH's unwanted conduct of an S nature which adversely affects another person's conditions of employment and or employment environment. Such harassment includes but is not limited to any unwelcome S advances, requests for S favor, and other verbal, nonverbal, or physical conduct of a S nature that interferes with work, is made a condition of employment, or creates an intimidating, hostile, or offensive environment in connection to the workplace, or the use of one's authority or power either explicitly or implicitly to coerce another into unwanted S relations, or to punish another for his or her refusal. For the avoidance of doubt, SH may occur between or amongst persons of different sexes or genders, or of the same sex or gender, and may be initiated by genders or whatever. Okay. In the event company is aware of any SH conducted by artist, company shall have the right to immediately terminate this agreement and available to all rights and remedies hereunder. So her, ad-libbing a kiss to him in that one scene, she did kind of SH Baldoni, right? Which I think is a violation of those terms, but we'll just keep going. The ALA was not signed when, this is the key part, the ALA was not signed when the first phase of filming began 1 week later on May 15th, 2023. In fact, although negotiations continued for more than a year, the parties agree that Lively never signed the ALA. On May 19th, 2023, Lively's lawyers sent Lanius an email stating, thank you for sending the long form. We will review and come back to you with our comments. In the meantime, since principal photography has commenced, until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the offer letter, with the understanding that the lender and artist are now unconditionally pay or play for the acting fee of $1.75 million, and that the conditions in paragraph 13 of the deal memo, the conditions precedent section, are now either satisfied or waived. Wait, how much did she make? What's this 1.75? Does anyone know in the chat? There is no evidence of a response from counsel for It Ends With Us movie, and principal photography continued. We're only on page 16 of 152. How are you guys doing? Hello, hello. Oh, Mrs. Busted Cans of Biscuits. Hello. You're so happy. It's such a great day. I am so happy too. I mean, really. I just never thought we'd see justice in this case. Michelle says, I'm testing out new prescriptions, including progressives. This is one of the few times I'm seeing my age. Oh, you mean for glasses? Sorry, I tried to make it bigger on the screen. Okay. I don't think I see any more things in here. Yes, NAG is amazing. Oh, thank you so much, Laura, for putting it in. And again, thank you to Laura and just Khaleesi and Christina, my amazing mods. Like, I feel like we've been through so much with this trial, with this case, and like, it's awesome you're here, because I know it's been nonstop today, and I understand, honestly, if you have to go, because I'm just going to be reading here maybe for another little bit. So, there's no pressure to stick around. I love you guys. Thank you again. I'm just going to keep reading for those that that it's easier to just hear it being read to them. So I'm going to keep going. All right. In February 2024, approximately 9 months after It Ends With Us movie first shared a draft of the ALA with Lively, and just days before filming wrapped, Lively's representatives finally sent It Ends With Us a marked up version of the agreement. Lively proposed revisions to approximately 20% of its provisions, including ones related to execution of the ALA, publicity limitations, and still approvals, SH, and confidentiality. Among other things, Lively's counsel amended paragraph 7 of the standard terms, the SH provision, to add that SH was not only cause for immediate termination of this agreement by a company, but also by artist. Shapiro Declaration. Counsel further added the following sentence to the conclusion of paragraph 7. In the event artist is aware of any SH conducted by company, notwithstanding the terms of paragraph 16.6 below, lender and or artist shall have the right to terminate this agreement, shall remain entitled to full compensation, and shall have the right to avail themselves of all rights and remedies hereunder and under applicable law. Elsewhere in the ALA, Lively's counsel struck from the document two conditions precedent specifying the Ends With Us movie's obligations under the agreement were conditioned upon its receiving executed copies of the ALA signed by lender and artist, and executed executed copies of the inducement attached to the agreement. Counsel comment bubbles to these provisions stating company has effectively waived the condition in practice, and of course this is part of signing a long form, but it is not a condition precedent to your obligations at this point. At this point in time, filming has nearly concluded and the parties had already conferred certain benefits upon one another. Lively had provided her acting services to It Ends With Us movie. It Ends With Us movie, meanwhile, had wired Lively's upfront fee of $1.75 million, less a 6.37 New Jersey withholding tax to Lively's client trust account at WME. It Ends With Us movie did so even before the offer letter was finalized. It also had paid for Lively's meal and training allowances and booked her travel. Doesn't she have her own plane? Okay. It Ends With Us counsel flatly rejected these proposed revisions in correspondence on March 7th. Oh, she wanted them to pay for her plane, maybe? Oh my God. It Ends With Us movies counsel flatly rejected these proposed revisions in correspondence on March 7th, 2024. With respect to the sentence added to the end of the SH provision, It Ends With Us movie wrote, "This is not acceptable. There can be no instances where there is a right to terminate the agreement or have a right of injunctive relief." It Ends With Us movie also rejected Lively's attempts to remove the conditions am I saying it right? Precedent or precedent? Conditions precedent from the agreement. In response to Lively's assertion from the requirement of an executed ALA have been effectively waived in practice, It Ends With Us movie counsel stated it still needs to be left in as it is always in every deal I have ever done. It Ends With Us movie similarly responded to the comment bubble asserting that execution of the inducement was not a condition precedent to your obligations at this point, stating yes, having a signed agreement along with all exhibits is always a condition precedent. Sorry if I'm saying that wrong. Disagreement over these terms continued, with Lively introducing the edits in a draft on April 18th, 2024. Shapiro declaration. Okay, and It Ends With Us movie rejecting them once again in a subsequent draft. Following these exchanges, he told Lively's representatives in a May 3rd, 2024 email that we have withdrawn our request for your client to sign her agreement in order to extend the time with the edit. The end of the email notes, as for future resolution of the contract, we will stand by in hopes that we come to a conclusion soon. So let me check in with you guys. Mrs. Buzzkid Cans of Biscuit says, I'm having a huge piece of lemon blueberry sourdough pound cake in celebration. Lemon pound cake, you guys, like that's still my that just like made my year. I still think that is the case of the year. The Afro Man case. I mean, it made Blake Lively look so stupid for what she's doing. Like, he's a celebrity, like fighting for the First Amendment. He's making like content out of it. He's turning, he's turning lemons into lemonade and lemon pound cake. And just, if you haven't, I have a playlist of my coverage of Afro Man. We had it here first on my channel. We covered it right when it happened right after it happened that day, before MSN did. And we had a great laugh together. Oh, Laura, I love you too. She's like, love you, still here. Page 16 of 152. I'm not reading the whole thing, okay? It says, I pulled my sister into this and she's had to end up keeping me up to date. My baby says, yeah, this case really. But let's just keep going. We're going to keep going with this. He wants him now. You guys, there was a Bath and Body Works candle sale that I just participated in because one of the candles was lemon pound cake. And I'm like, I'm going to need that. I'm going to need that to celebrate since I don't know how to cook lemon pound cake. And that's for another day. So celebrate however you guys can. And let me get back to this. One second. I'm going to get some. I mean, who do you guys think is more stupid? Like, do you think that the cops in the Afro Man case are more ridiculous for suing for like defamation and for harassment for getting lemon pound cake sent to the office, or Blake Lively for whatever this is? For like, and what's so funny here is like, for this, I think the retaliation, right, is based on this alleged like defamation or whatever, like filing back, or who knows really what it is. But what's funny to me is that, like, if she goes with that, then Wayfair's gonna be able to bring in all the things she did to herself to, like, make her look ridiculous to her own reputation. She was damaging her own reputation way before this movie happened. And if you don't believe me, go check out the Bushbirds. They've been reading the comment sections on things that she's done going years back. Okay, keep reading the document. Okay, I'm going to keep going. Sorry. I gotcha. We're going. Page 18 of 152. The parties exchanged a final draft of the ALA on July 2nd, 2024, with disputes regarding the contested provisions still unresolved and Lively's proposed additions once again struck from the document. In that correspondence, Mezzanine wrote of Lively's counsel seeking an expedited review and signature. Mezzanine's request followed a similar one she made 2 months earlier, to which Lively's representatives had responded at the time. We, Blake's representatives, are all speaking this week about the open issues and will come back to you soon. Notwithstanding these and other requests, Lively never signed the ALA. God, Lyman, it took you like 2 pages to say this. Non-party Sony executive Ange Giannetti stating that Wayfair had, quote, been trying to get Lively to sign her deal for over a year, end quote. Baldoni stating in June 2024 text that Lively, quote, won't sign her contract. Oh my God. That brings the court to the CRA, the other agreement under which Lively seeks relief. As previously noted, filming paused on June 14, 2023, approximately 1 month after it began, due to the Writers Guilds of America and SAG-AFTRA strikes. In an email on November 9, 2023, Lively's attorneys informed Meziane, I think that's how you say it, and Lanius that Lively's experience during the first phase of filming had been deeply concerning on many levels, and that a list of protections would need to be guaranteed and observed by the film's producers in order for Lively to feel safe to the production. To feel safe returning to the production. The email states that while we reserve all legal rights, at this stage, our client is willing to forgo a more formal HR process in favor of everyone returning to work and finishing the film, as long as the set is safe moving forward. It continues that if the production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. 2 days later, Meziane responded, quote, Wayfair, Sony, and production respectfully acknowledge that your client has concerns regarding safety, professionalism, and workplace culture. Although our perspective differs in many aspects, ensuring a safe environment for all involved is paramount. Irrespective of differing viewpoints regarding your outline request, we find most of them not only reasonable, but also essential for the benefit of all parties moving forward. Although Meziane agreed to many of the protections, she sought clarification regarding others and stated that, one, Lively's request to engage an additional producer to supervise the production was not viable. Yeah, because it's insane. Lively's representatives replied that the list provided was not intended as a starting point for a negotiation, but rather was necessary for Lively to return to work. The representative further requested that Mezzanine respond, quote, as soon as possible, whether Wayfair will agree to accept all of the protections, including in our original communication. On December 15, 2023, Lively provided Meziane with a side letter which outlined the list of 17 protections provided in the November email, along with certain updates and, quote, minor modifications. Lanius confirmed receipt of this document, also known as the Contract Writer Agreement, or CRA, and in an email on January 3, 2024, proposed certain revisions. On or about January 19, 2024, Heath, acting on behalf of It Ends With Us, signed the CRA. Lively also signed the agreement. Sony executive Ange Giannetti, known as Giannetti, testified at her deposition that It Ends With Us movie executed the CRA because there was a tremendous amount of money that had been invested and spent, and we had to finish the movie or it was unreleasable. The final CRA, so she was holding them hostage with this. The final CRA begins by stating that reference is made to the ALA and that the parties, meaning It Ends With Us movie as company, Blakel Inc. as lender, and Lively as artist, wish to confirm the conditions under which lender has agreed to cause artist to render acting services on the picture following the break in production of picture related to the 2023 WGA and SAG-AFTRA labor strikes. A prior version of the CRA referred to the ALA as unexecuted, but Lanius deleted that word in a draft among other edits. The CRA further states that for good and valuable consideration, the receipt of which is hereby acknowledged, It Ends With This movie agrees to certain additional terms and conditions including the following condition found in paragraph 10. There shall be no retaliation. Oh God. There shall be no retaliation of any kind against artists for raising concerns about the conduct described in this letter or for these requirements, any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work as a result of these requests, is retaliatory and unacceptable and will be met with immediate action. You guys, sarcasm. Oh my God. The CRA states that in the event of any conflict between the terms and conditions of the agreement and the terms of the conditions of the side letter agreement, the term and conditions of the side letter agreement shall control. Although the initial November email with the protections for return to production indicated that if the protections were acceded to, Lively was willing to forego a formal HR process. The CRA contains no such promise on its face. When the CRA was signed in January 2024, the parties were still actively negotiating at least certain portions of the ALA, including the provision governing SH, and no long-form agreement had been signed. B. The ALA is unenforceable. It Ends With Us movie and Wayfarer contended principally that the ALA was never validly formed and is unenforceable against them because the agreement contains conditions precedent, namely execution of the agreement and Lively signing of the inducement that did not occur. Lively responds that they are stopped from raising such an argument by their prior efforts to enforce the agreement and that in any event, they have waived the conditions through their conduct and in writing. Before turning to the merits of these arguments, the court addresses two preliminary issues. The first relates to choice of law. In discussing the contract claim, the parties both invoke California and New York law. The court will do the same, as courts have observed that New York and California apply substantially similar rules for determining whether the parties have mutually assented to a contract term. Meyer versus Uber Tech is a 2017 case. They also quoting Schnabel versus Triligent Corp, 2012 case. Also see Plaza versus Airbnb Inc., which is an SDNY 2018 case. Okay, noting the New York and California apply substantially similar law with respect to contract formation, citing Nguyen versus Barnes & Noble, 2014. Furthermore, to the extent the two states' laws do conflict on such issues, any differences are immaterial, as detailed below. The Wayfarer parties also make certain alternative arguments going beyond formation, which assume arguendo that ALA is binding. Because these arguments take the ALA's validity as their premise, the court analyzes them in accordance with the ALA California choice of law provision. Do you want me to read that? There's a really long footnote here. Let me check in with you guys. Do you find this educational? Laurie Jane says, we need to send Blake lemon pound cake. That would be so funny. She would call it like lemon pound plantation cake. Let me see. Mrs. Busted Cans of Biscuit says it's going to be wild the next week, the scrambling. I can't stop hypothesizing what's going on in the Reynolds Lively home tonight. Their attorneys probably have a new beehole the size of a Boosie's. Oh, the size of a Bucky's. You guys are so funny. Well, I mean, just allegedly, I heard, LIMEN Poundcake. Oh my gosh, Kenny, you are so creative. I love that. You should copyright that. and make a song about it. LIMEN Poundcake. Oh my god, that'd be so funny. Yes, please resolve it. Okay, DFJ. Thank you, Michelle's. I will. Look at your cute little puppy. I always love seeing them. Okay. With hair. So yes, let's keep going. Kenny, seriously, you gotta do that song. If you want. LIMEN Poundcake. To this case, that'd be hilarious. But I do think that in her house tonight, I heard that Ryan Reynolds has quite a temper. So I can imagine he's probably ripping Count Gottlieb and what's the other one? Elmo Ezra. I have a feeling he's like ripping them a new one. And do you think I hope they were paid up front. Okay, we're going back to this. We are on page 20. We're almost on page 22. I still have a footnote left, but 1 second. I just need to get a quick sip of tea. Okay. The Wayfair parties do not similarly presume the applicability of the ALA's California choice of law provision with respect to issues of contract formation. They instead argue with some force that contractual choice of law provisions have no bearing on questions of contract formation and that would presume the applicability of a provision before its adoption by the parties has been established. The court need not accept that argument for present purposes, for as previously indicated, any differences between the state's law are immaterial. The court notes, however, that at least in the arbitration context, which involves distinct considerations and interests, the Second Circuit has rejected a similar opposition. See Commodities and Mints Enter Limited versus CVG Ferrominera Orinoco. Okay. It just says holding that where the validity of the choice of law clause is not specifically challenged, the choice of law provision governs even with respect to issues of contract formation. See also, okay, International Minerals and Resolute something SA versus Papa's, applying choice of law clause in arbitration context to an issue of contract formation. Okay, hold on. Let me just make sure. Sorry, I just want to do one more thing. Okay, you guys can still see it. Okay, good. We are on page 22. The second preliminary issue is which defendants are now subject to Lively's contract claims. The SAC pleads contract claims against both It Ends With Us movie and Wayfair. It is undisputed that only It Ends With Us movie and not Wayfair is a party to the ALA and the CRA. The Wayfair therefore argues in its opening brief that it is not liable under the agreements. In her Rule 56.1 statement, Lively suggests that Wayfair is bound by the agreements even if it is not listed as a party. Her brief in opposition to the motion for summary judgment, however, fails entirely to respond to the Wayfair party's argument as to why Wayfair should not be held liable under these agreements. Kind of does a mic drop there. Mic drop. Can you guys hear me? Okay, good. Wow. Her brief in opposition to the motion for summary judgment, however, fails entirely to respond to the Wayfair party's arguments as to why Wayfair should not be held liable under the agreement. And so many people have been saying that so many times when that came out. And so I'm glad he saw that. Given this failure to respond and viewing the papers and circumstances as a whole, the court deems her contract claims against Wayfair abandoned. Jackson versus Federal Express. See also, in the case of a counseled party, a court may, where appropriate, infer from a party's partial opposition to a motion for summary judgment the relevant claims or defenses that are not defended have been abandoned. Okay, estoppel. Lively asserts that the Wayfair party's arguments regarding the validity and enforceability of the ALA are all beside the point because the Wayfair parties themselves previously sought to enforce the agreement against Lively and are therefore estopped from disputing its enforceability now. Judicial estoppel applies where, 1, a party's later position is clearly inconsistent with its earlier position. 2, the party's former position has been adopted in some way by the court in the earlier proceeding. And 3, the party asserting the two positions would derive an unfair advantage against the party seeking estoppel. We have a footnote here. Whether Wayfarer qualified as It Ends With Us movie's alter ego such that it can be held liable under contracts entered into by It Ends With Us movie is conceptually distinct from whether It Ends With Us movie and Wayfarer were Lively's joint employers, an issue which Lively has not waived. Okay. The Second Circuit has further limited estoppel to situations where the risk of inconsistent results with its impact on judicial integrity is certain. Those circumstances are inapplicable here. Lively's argument is predicated upon the Wayfarer's party's assertions of a claim of breach of the implied covenant of good faith and fair dealing filed in this court on January 16, 2025. In an amended complaint filed January 31st, 2025, the Wayfarer parties alleged In an amended complaint filed on January 31st, 2025, the Wayfarer parties alleged a claim against Lively for breach of the implied covenant of good faith and fair dealing. Lively moved to dismiss the amended complaint, arguing in relevant part that the implied covenant claim had to be rejected because the Wayfarer parties had failed to identify the relevant contract, any of its terms, who it was with, or how it was breached. The Wayfarer parties opposed that motion without specifying a provision of a contract under which their claim arose, but also while quoting a fragment of a sentence of language that appears in the ALA without citation. Wayfarer Action Docket 83 at 32, quoting language that Lively agreed not to interfere with the complete enjoyment of the rights and privileges granted to Wayfarer, language which appears in the ALA but not in the offer letter. Compare Shapiro Declaration. Okay. The Wayfarer parties did not attach the ALA to the amended complaint, and the quoted fragment appeared nowhere in the complaint. In its June 9th, 2025 opinion and order granting the motion to dismiss the amended complaint, the court dismissed the Wayfarer parties' implied covenant claim on the grounds that the complaint's allegations were conclusory and failed to identify the relevant contract which individuals were parties to, when it was made, or what the relevant terms were. And I'm sorry, I just have to interfere here for 1 second just to say that I cannot believe he's justifying dismissing their complaint. That's such BS in my opinion, because whatever. I'm glad Lyman got this right today, but let's not hold him up on a pedestal by any means, because he still did a lot of wrong here, in my opinion. And that still pisses me off that he dismissed, especially the defamation claim. Because as we learned, there was proof of that came out later, because that's what happens when you file a lawsuit and you do discovery. Lively's estoppel argument is without merit because the Wayfarer parties did not previously assert that the ALA was enforceable, nor did the court adopt any such position. In dismissing the Wayfarer parties' amended complaint, the court concluded that they had provided insufficient information regarding the specific contract under which they were suing. It granted them leave to replead their contract claim with allegations identifying the relevant agreement and provisions, which they chose not to do. The court holding, because they didn't want to be before this stupid judge again. The court's holding, therefore, necessarily did not address whether the ALA was validly formed or enforceable. The risk of any inconsistent results is therefore not only far from certain, but non-existent. For similar reasons, there is no apparent possibility of an unfair advantage. To the extent Lively argues that the Wayfarer parties should be prevented from disputing the ALA's validity, not under the doctrine of judicial estoppel, but under the different framework of waiver, the court addresses and rejects the contention below. We have a footnote. Furthermore, the Wayfarer parties' current position is not clearly inconsistent with an earlier one. Again, the thrust of the court's prior opinion and order was that it was unclear which agreement that Wayfarer parties were suing under. It still is. The amended complaint referred to a contract by which Lively agreed to perform as an actor in the film It Ends With Us, but that could be a reference to the offer letter, which the Wayfarer parties concede was a binding agreement. To be sure, in their brief in opposition to the motion to dismiss, the Wayfarer parties quote part of a sentence that appears in the ALA and not in the offer letter. But that passing reference without citation in a brief in opposition does not clearly establish for estoppel purposes that the Wayfarer parties were suing under the ALA. At the very least, At the very least, it is not obvious that their current position is inconsistent with the prior one. Judicial estoppel is thus improper. We are on page 25, part 2, contract formation. You guys still here? Doing good? I think I have a whole 17 people here. I'm not sure if this is like, if I should keep doing this or not. You guys let me know. I'll keep going for now. Contract formation. It Ends With Us movie raises two variants of the same core agreement regarding why the ALA is unenforceable. First, it contends that the ALA was never validly formed and binding contract because the It Ends With Us movie expressed an intent not to be bound until Lively executed and signed the contract. It Ends With Us movie never renounced that intent, and Lively never executed and signed the agreement. Second, It Ends With Us movie contends that even if the ALA was a binding contract, it specifically provided that It Ends With Us movie's obligations did not arise until the signing of the agreement. Because that condition never occurred, its obligations never kicked in, and it cannot be held liable under the agreement. These two arguments, therefore, end up in similar places throughout different doctrinal routes. The court will address both, turning first to the issue of formation. Mutual intention to be bound by an agreement is the sine qua non of legally enforceable contracts, and recognition of this requirement is nearly universal. Casa del Cafe Vergnamino versus Italian Flavors LLC. And then we're going down to, mutually assent is essential to the formation of a contract, and a party cannot be held to have contracted if there was no assent or acceptance. From this foundational principle, it follows that if either party communicates an intent not to be bound until he achieves a fully executed document, no amount of negotiation or oral agreement to specific terms will result in the formation of a binding contract. Instances, media, fair entertainment. If there is a manifest intention that the formal agreement is not to be completed until reduced to a formal writing to be executed, there is no binding contract until that is done. Put another way, when the circumstances and evidence suggest that both parties contemplate that acceptance of a contract's terms would be signified in writing, the failure to sign the agreement means that no binding contract is created. They just cite a lot of case law there. Okay, this touchstone of contract formation, intention to be bound, must be assessed based on the totality of the circumstances, including the parties' words and conduct. Mutual assent is determined under an objective standard applied to the outward manifestations or expressions of the party, the reasonable meaning of their words and acts. Questions of intent to be bound often arise in situations involving preliminary agreements that call for the subsequent execution of more formal instruments. The Second Circuit has identified two types of agreements. The first arises where parties agree on all points that require negotiation, including whether to be bound, and they contemplate memorializing those points in a more formal document. Such agreements are fully binding as they are preliminary only in form, only in the sense that the parties desire a more elaborate formation and agreement. The second situation arises where the parties agree to some major terms, but others remain to be negotiated. In this context, courts look to certain factors to determine whether the parties intend to be bound, including 1, the language of the agreement, 2, the context of the negotiations, 3, the existence of open terms, 4, partial performance, and 5, the necessity of putting the agreement in final form as indicated by the customary form of such transactions. See Winston. Okay. Applying these factors and noting the parties' agreement that New York and California law do not conflict. Okay, in considering these factors, the first is frequently the most important, Brown versus Cara. And there is a strong presumption against finding binding obligation in agreements which include open terms, call for future approvals, and expressly anticipate future preparation and execution of contract documents. Considerable weight is put on a party's explicit statement that it reserves the right to be bound only when a written agreement is signed. That said, courts must remain mindful that these factors help us identify categories of facts that are often useful in resolving disputes of the sort, but they do not provide us with a talismanic scorecard. The ultimate issue, as always, is the intent of the parties, whether the parties intended to be bound, and if so, to what extent. Applying these standards to the facts of this case, it is clear that the ALA is not and has never been a validly formed and binding contract, as it ends with us movie unambiguously express an intent not to be bound absent a fully executed and signed agreement. Consider first the language of the agreement. In both the offer letter and the ALA, it ends with us movie expressly reserved the right not to be bound prior to execution. Paragraph 13 of the offer letter states, producers' obligations to artists hereunder shall be subject to full execution by artist, lender, and producer of an agreement in a form reasonably acceptable to all parties. I just have a question. Do you guys think that like he's like saying the same thing over and over and over and over, kind of like just overwhelming Lively's legal counsel the way that they have to him on these BS claims this entire time? Just a question. Good night, Laura. See you later. Yes, Jungle Veg Jill says this is Blake and Ryan's first slap of reality, and dollars to donuts. They still think they can change public opinion. You know, I said it before that, like, I just said I hate that. Hold on one second, you guys. Someone's at my door. Hold on one second. Okay, sorry about that. We're back. What I said before though is that yeah, Judge Lyman was, basically bending over for Lively this whole time, and I was like, at the end of the day, she's going to throw him under the bus, and that's what their PR is doing. So they're blaming the judge and whatnot, and then some people are claiming technicalities, which I don't really think this is a technicality. I think when you need someone's birthing video to prove like that you were somehow harassed, I think you're the pervert. Like, I think Lively is the pervert for thinking that childbirth is corn. That is the most disgusting thing I've ever heard, and I hope she gets her head checked. Okay, let's keep going. We're on page 28. The ALA contains similar language. The first draft and all subsequent ones shared by It Ends With Us movie assert that It Ends With Us movie is not to be bound absent receipt of executed copies of this agreement signed by lender and artist. The ALA also states that It Ends With Us movie is not to be bound unless it receives the inducement attached hereto and incorporated herein by this reference, fully executed by lender and artist. This express reservation of rights, absent a signed writing, in not one or two, but three different places, is compelling evidence that there was no mutual assessment to the formation of a contract. An inference finds support elsewhere in the ALA. The agreement contains a merger clause, which specifies that the parties' agreement is expressed entirely in the document, and that it may not be modified, altered, or amended unless in writing and signed by both parties. The standard terms also contain a provision requiring amendment to be in a written instrument executed by company and artist. The presence of such a merger clause is persuasive evidence that the parties did not intend to be bound prior to the execution of a written agreement. Okay, where a question of intention is determinable by written agreements, the question is one of the law appropriately decided on a motion for summary judgment. That is the case here. The written agreement included open terms, call for future approvals, and expressly anticipated future preparation and execution of contract documents. The message is clear. It Ends With Us movie did not intend to be bound prior to execution. Since in this case, intent can readily be determined by examining the agreement, summary judgment is perfectly appropriate, even if there was considerable partial performance. Additional factors, including the context of the negotiations, confirm what the agreements on their face suggest. It ends with this movie on multiple occasions sought Lively's signature on the ALA. Lively, on multiple occasions, withheld it. Those requests and that withholding were not meaningless. They evidence the parties' shared understanding that execution of the ALA carried with it legal consequences. Lively argues that her withholding of her signature suggests at most that the parties continued to disagree over a limited subset of terms, in her estimation about 20%, not that they disagreed over the formation of the contract in general, but 20% of an agreement's provisions is not an insubstantial amount, and the specific provisions at issue also are not insignificant or immaterial to issues of formation. One of the contested provisions is the very one under which Lively now sues, paragraph 7, which prohibits SH and retaliation. Lively contends that the parties' disagreement over paragraph 7 centered on her right to injunctive relief, which is not at issue here, and that there is no evidence the parties disagreed over the rest of the provision. That slices matters too finely. The court cannot infer a party's agreement to parts of a provision from the fact that the party has expressly disagreed to other parts of the same provision. It is an elemental principle of contract law that a written contract will be read as a whole and every part will be interpreted with references to the whole. Chem Image Corp. Versus Johnson & Johnson. The question whether Lively would have unilateral right to halt production of the film if, in her view, SH occurred is hardly inconsequential. The fact that the parties were not able to come to terms on such provision provides powerful evidence that no contract had yet been formed. I feel like he said the same thing now for the past 20 pages. Is it just me? Okay, I have 9 people, you guys, here. That's it. We're just reading this if anyone wants to stick around. Okay, resisting this conclusion, Lively contends that the parties' partial performance of the ALA and their written statements about it reveal that they intended to be bound notwithstanding the agreement's clear language to the contrary and the parties' continued negotiations. The court disagrees. Considering Lively's evidence both in isolation and as a whole, it fails to raise a genuine issue of material fact concerning formation of the ALA. To start, Lively asserts that it ends with this movie intent to proceed with the agreement can be inferred from the fact that it performed the material terms of the ALA. Had there been no contract, Lively argues, that Ends With Us movies would have had no reason to perform under it. Partial performance is relevant as one party's partial performance of the alleged contract and the other party's acceptance of that performance shows that both parties understood a contract to be in effect. However, as the Wayfarer parties argue, their performance took place under the offer letter, not the ALA. After filing began and well before Lively responded to the Wayfarer party's draft of the ALA, Lively's counsel stated to It Ends With Us movie that because principal photography had commenced until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the negotiated deal memo. It Ends With Us movie did not respond and thus tacitly accepted that position, treating the offer letter as a binding agreement. Lively cites It Ends With Us movie's conduct after it circulated a draft of the ALA, but each act was consistent with the offer letter. Lively cites It Ends With Us movie's payment to Blakel of meal and training allowances as proof that It Ends With Us movie performed under the ALA, but the offer letter also provides for such allowances. Lively also observes that It Ends With Us movie chartered a private plane for her travel. My goodness. The offer letter requires It Ends With Us movie to provide private round-trip air transportation for Lively during shoots outside of New Jersey and New York. The parties' conduct during filming therefore reinforces what Lively's counsel made explicit, that the parties would perform under the offer letter until such time that the long form is fully executed. As for the parties' post-filming conduct, Lively argues that she was paid after the film's release in accordance with the more generous contingent compensation agreement outlined in the ALA rather than under the offer letter. But a party can provide a more generous benefit to a counterpart in anticipation that an agreement will be reached without at the same time committing itself to all the terms in a written agreement before the agreement is reached. Holding that parties' partial performance under an agreement was insufficient to raise a genuine issue for trial regarding contract formations. Same even where partial performance strongly favored finding existence of a contract. That is the case here. There is no evidence that It Ends With Us movie provided those benefits because it believed that it was bound by the ALA. By the time of post-production, Lively had repeatedly rebuffed It Ends With Us movies and treaties for her to sign the ALA. It Ends With Us movie had also repeatedly and unequivocally rejected Lively's counsel's attempts to strike the execution language from the agreement. Even assuming that Lively is correct and that It Ends With Us movie paid her under the ALA, the partial performance cannot reasonably be understood to reflect what would be a conspicuously silent change of heart on It Ends With Us movie's part. Lively also relies on certain statements made by the parties during negotiations as further evidence of their intent to be bound. These likewise fail to raise a triable issue as they cannot fairly be read to carry the implications Lively assigns to them. First, Lively points out that when her counsel sought to strike the conditions precedent from the ALA on the grounds that they had been effectively waived in practice, It Ends With Us movie's counsel responded to that conditions should still remain because they are always in every deal I have ever done. Lively contends that because It Ends With Us movies counsel did not expressly dispute waiver of the conditions precedent, It Ends With Us movie conceded the issue. A party need not use the magic words, I contest waiver, where its actions do just that. The conduct said to constitute a waiver must be clear and unequivocal, as waivers are never to be lightly inferred. That's Morningstar Films case. Waiver requires clear, unequivocal conduct and may not be inferred from mere silence or inaction. It Ends With Us movie refused to agree to remove the relevant language, continuing to insist that Lively deliver a final executed copy of the ALA before it would be bound. Nor does Heath's email to Lively's representative on May 3rd, 2024, provide evidence of an intent to enter into the ALA. At the time, the parties still had not reached agreement on the terms of the ALA. It Ends With Us movie had rejected Lively's proposed changes to the ALA. Lively states that Heath, in the email, expressly confirmed in writing that Wayfair was waiving the execution conditions, but that is misleading. In its entirety, the relevant sentence from the email reads, "We have withdrawn our request for your client to sign her agreement in order to extend the time with the edit." The email continues, "As for the future resolution of the contract, we will stand by in hopes that we come to a conclusion soon." Clearly, Heath did not understand the contract to be resolved or concluded, nor did he agree that Lively did not need to deliver final executed copies of the ALA. He merely communicated that Lively could edit the film while negotiations were ongoing. Indeed, after this email, It Ends With Us movie continued requesting Lively's expedited review and signature on the ALA, and Lively continued to refuse to do so. Baldoni stating on June 1st, 2024 text that Lively won't sign her contract. Finally, Lively seizes on the fact that on January 3rd, 2024, during the negotiations over the CRA, It Ends With Us movie struck the word unexecuted from the phrase unexecuted actor agreement. The fully executed CRA states that reference is made to that certain actor agreement, whereas the draft CRA previously stated reference is made to the certain unexecuted actor agreement. There are no discussions or other materials on the record shining any light on that edit. The edit cannot be read as evincing the parties' mutual intent to be bound by the then extant copy of the ALA. At the time the edit was made and the CRA was executed, Lively's counsel had not yet gotten back to It Ends With Us movie with its promised comments on the draft long form. Lively had not even suggested the changes to the ALA that she now relies upon and that are at issue in this case, example, those over SH. At most, The edit reflects It Ends With Us movie's hope and expectation that there would be an actor agreement and that once there was such an agreement, the CRA would survive the execution of that agreement. Therefore, the parties continued to negotiate over the ALA's terms to go back and forth over the issue of Lively's signature. It Ends With Us movie continued to demand that there be a final executed copy of the ALA before it was bound, and Lively declined to provide such a copy. There clearly was not an executed ALA at the time the CRA was signed. Ultimately, Lively fails to confront what is the central dilemma in her claim. She contends that the ALA became binding on It Ends With Us movie at some point while the parties were still negotiating it, but she cannot pinpoint a time when the parties began to be bound by it or which version of the ALA they were bound to. The existence of a contract requires a mutual assent and intent to be bound. Unless both parties are bound, neither party is bound. Which draft of the ALA bound Lively? ? Was it the version that lacked the SH provision? At oral argument, Lively's counsel suggested that the ALA became binding once the parties began performing under their agreement, which counsel stated was at the beginning of filming in May 2023. But if that is so, it would mean that the ALA became binding before the SH provision was even proposed. And if it became binding at some point later, Lively cannot identify when exactly there was an agreement and what that agreement specified. The only conclusion that an undisputed facts would support is that the parties performed services pursuant to the offer letter. It is that document which Lively, through counsel, said she would perform until such time that the long form is executed. And it is only that document under which It Ends With Us movie accepted her performance. In sum, the contract drafts, combined with the parties' other written communications and actions, conclusively establish It Ends With Us movie's intent not to be bound to the ALA prior to its execution. Absent such intent, the ALA was never validly formed. Lively's contract claims under the agreement must therefore be rejected. Yay. Let me check in. Oh, hello, everyone. You want me to keep going? What time is Lauren on? Is it 8:30, I think? I'm just going to make sure to stop before that. I mean, or I could keep, it's not like I'm taking away from her audience. Okay, hold on one second. Kenny, denied. Sit down. Right? Denied. I love it. I wish it didn't take him so long to get there, but I love it. Okay, we are on page 35. Waiver of the conditions. Okay, can you at least someone in the chat tell me how I say that? Is it precedent or precedent? Vague, I know you know. I'm going to look like a fool for saying it wrong. I don't see anyone. All right, well, I'm just going to keep saying it. However I feel like saying it. In the alternative, It Ends With Us movie. And if I say it wrong, feel free to put it in the comments. If you put a comment in the video, it like helps with the algo at the end if you're on replay crew. All right. Waiver of the conditions precedent. In the alternative, It Ends With Us movie argues that even if the ALA was validly formed, its terms provided that It Ends With Us movie's obligations did not arise until Lively signed the agreement. Because that never happened, It Ends With Us movie contends that it cannot be held liable. Lively responds that It Ends With Us movie waived the condition that there be a signed and executed ALA before It Ends With Us movie was bound by its terms. Waiver is a cousin to contract formation. Contract formation goes to whether there was an enforceable agreement between the parties at all. Waiver goes to whether, assuming an enforceable agreement, It Ends With Us movie voluntarily and knowingly abandoned the term that it would not be bound until Lively delivered final executed copies of the ALA. Williston on contracts. Okay, never mind. It Ends With Us movie arguments on this front succeed for largely the same reasons that the arguments above do. California law defines conditions precedent. Let me see what you guys are saying. Oh, it is precedent. See, that's what I thought originally, not precedent. Okay. Well, I was saying precedent, but then it sounded weird. For some reason, I felt like I wasn't saying it right. It is precedent. Okay. All right. We're there. Thank you. You guys are such smarty pants. California law defines conditions precedent as a contract term that is to be performed before some right dependent thereon accrues and some act dependent thereon is performed. Such a term may be waived by the party it is intended to benefit. A party to a contract waives a contractual right by indicating an intent to relinquish the right. The waiver may be either express based on the words of the waiving party or implied based on conduct that is so inconsistent with an intent to enforce the right as to induce a reasonable belief that such right has been relinquished. In all instances, the pivotal issue is the intention of the party who allegedly relinquished the known legal right. Moreover, whether accomplished expressly or impliedly through either words or conduct, the waiver must be demonstrated by clear and convincing evidence. The party opposing enforcement of the contract provision carries the burden, and doubtful cases will be decided against a waiver. Lively has not identified evidence to support that It Ends With Us movie intentionally waived the conditions precedent under the ALA. With respect to express waiver, Lively can only point to Heath's May 3rd, 2024 email in which he stated that we have withdrawn our request for your client to sign her agreement in order to extend the time with the edit. But as previously explained, Lively takes this email out of context. It does not demonstrate a complete and total waiver of the execution conditions, but only a temporary acknowledgement of Lively's ability to continue with the edit while negotiations were ongoing. It is undisputed that It Ends With Us movie continued asking for Lively to execute the contract after that point and that she declined to do so. As for implied waiver, neither It Ends With Us movie's conduct nor its words were so inconsistent with an intent to enforce the execution conditions as to raise the prospect of a purposeful abandonment of those rights. When Lively's counsel attempted to strike the conditions precedent from the ALA on the grounds that they had been waived in practice, and It Ends With This movie responded that the conditions still needed to be left in, that response did not implicitly concede that It Ends With Us movie had abandoned its rights under the conditions. It Ends With Us movie insistence on keeping the provision in the agreement established just the opposite. Furthermore, insofar as Lively's counsel suggested that the conditions had been waived by It Ends With Us movie's performance under the ALA, that contention failed to account for the fact that Lively herself indicated that she would proceed in reliance upon the terms of the negotiated deal memo, that is, the offer letter, until such time that the long form is fully executed. The only contract that It Ends With This movie could be deemed to have accepted in practice was the offer letter. Lively's suggestion that It Ends With Us movie's payment to her under the ALA proves It Ends With Us movie's waiver gets things backwards. Partial performance and acceptance of the benefits of performance typically affects waiver as to the party who accepted the benefits, not the other way around. They're just quoting, a bunch of stuff. The only benefit that Lively cites as having conferred on It Ends With Us movie is her performance in the film, but that performance was required by the offer letter. Lively, therefore, has not shown that It Ends With Us movie waived the conditions precedent by acceptance of any performance under the ALA. At oral argument, Lively's counsel also suggested that It Ends With Us movie waived the conditions precedent by bringing suit against Lively under the agreement. But even accepting as truth that It Ends With This movie was suing under the ALA as opposed to the offer letter, the conditions precedent in the agreement specify that It Ends With Us movie's obligations, not Lively's, were contingent upon Lively's signing of the contract. Thus, It Ends With Us movie's lawsuit was in no way inconsistent with any intent on It Ends With Us movie's behalf to enforce the conditions precedent in the ALA. The provisions went only one way. Lively, therefore, fails to present evidence that would demonstrate intentional relinquishment of It Ends With Us movie's rights under the ALA. It Ends With Us movie cannot be held liable under the agreement, even if it was validly formed. Wow. We're on page 38, but wow. Oh my gosh, Kitty says, I have a chorus and a bridge written for LIMEN Poundcake. Just got to write the 2 verses, which are the harder part. Wow, that's so fast. I don't know how you do that, but that is so fast. Okay, did I say that? I said this right? Okay. Not C. Okay, cool. I think I said, oh, look, there's Trish. Hi. Such a celebration, right? Yeah, thanks to everyone here. Okay, yes, if you'd like to buy me a coffee. I feel like I haven't slept in a week because Ozzy's thing happened last week. He's here with us. Okay, laying right next to me. Okay, notice and cure. Should we keep going? Yeah? All right, let's keep going. Okay. It Ends With Us movie offers one last reason why Lively's ALA claim must be rejected. It argues that there was no actionable breach of the agreement because Lively did not satisfy the ALA's notice and cure provision. The court agrees with It Ends With Us movie here too. It provides that no act or omission of company hereunder shall constitute an event of default or breach of this agreement unless artist shall first notify company in writing setting forth such alleged breach or default, and company shall not cure the same within 30 days after receipt of such notice. The ALA further provides that all notices required hereunder shall be in writing and addressed to It Ends With Us under the attention of Jamie Heath. It Ends With Us movie asserts that Lively never provided the requisite notice and opportunity to cure before asserting her breach of contract claim because the cease and desist letter she sent on December 20th, 2024 was not addressed to It Ends With Us movie and did not mention any alleged breach of the ALA. It Ends With Us movie further argues that even putting aside the fact that the letter was not sent to It Ends With Us movie and did not assert a breach of the ALA, Lively failed to comply with the contractual 30-day cure period by filing suit only 11 days after sending the cease and desist letter. Lively responds that It Ends With Us movie waived this defense by failing to plead it as an affirmative defense in its answers. She also contends that she complied with the provision because It Ends With Us movie had notice of its breach at least by December 31st, 2025, when she filed suit in this case, and 2, she filed her first and second amended complaints on February 18th, 2025 and July 30th, 2025 outside the 30-day window, hereby mooting any issue regarding It Ends With Us movie having an insufficient opportunity to cure. You know, do you guys know who Jane Guardian is? I feel like she's been like saying this from the beginning, and I feel like she's probably having a party right now. Like she's probably having her own party that she was right. I'm screenshotting that for her. Lively's first argument lacks merit because her failure to comply with the notice and cure provision in this context is not an affirmative defense. Under the terms of the ALA, notice and cure goes to an element of a claim for breach of contract, which the plaintiff and not the defendant must satisfy to prevail on her claim. The elements for a breach of contract claim under California law are 1, the existence of the contract, 2, plaintiff's performance or excuse for non-performance, 3, defendant's breach, and 4, the resulting damages to the plaintiff. The plaintiff in a breach of contract action bears the burden on each element. As a general matter, a notice and cure provision can implicate both the second and third prongs. With respect to the second element, courts have held that notice and an opportunity to cure is an element of performance that the plaintiff must satisfy before bringing a claim for breach of contract, holding that a plaintiff's failure to provide notice and opportunity to cure meant that the plaintiff could not prove an essential element of these breach claims. Plaintiff performance and granting summary judgment to the defendant on that basis. This is quoting some stuff. Blah, 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 blah. Okay. With respect to the third prong, where the contract expressly provides that no act or omission shall constitute a breach absence compliance with the notice and cure provision, a breach cannot be shown without demonstrating that notice and an opportunity to cure have been provided. Sorry, I'm just skipping a lot of the citations so it reads more smoothly. The California Court of Appeals decision in Silverado Modjeska Recreation and Park District versus County of Orange is instructive. That case is complicated in many respects, but involves a relatively straightforward contract claim. In short, the developer of a ranch entered into a contract with the county whereby the developer agreed to dedicate certain land as a permanent open space and contribute funds for cleanup, restoration, and enhancement of this space on the condition that the county agreed not to appeal and or litigate the developer's plans for the project site. The agreement further provided that the county would indemnify the developer from any and all liabilities or expenses, including attorney's fees caused by the county's breach of the agreement. The county subsequently initiated suit, and the developer therefore argued breach and sought fees under the agreement. The district court granted the developer's motion after finding that the county breached the agreement by filing suit. The Court of Appeal reversed, concluding that the trial court's ruling that the county breached the agreement was erroneous because the agreement expressly defines a breach as the failure to cure an alleged breach after receipt of proper notice of the alleged breach, and the developer failed to give the county proper notice of breach. Much like the agreement here, the contract in Silverado stated that a party shall be deemed in breach of this agreement only upon the failure to perform any obligation under this agreement after receipt of written notice of breach and failure to cure such breach within 30 days thereafter. The court noted that the agreement did not simply require that a party give notice of breach as a prerequisite to bring in an action for breach, but rather it defined breach as the failure to perform any obligation after receipt of written notice of breach and failure to occur within 30 days after receipt of notice. The agreement also specified, as here, that all notices required herein shall be in writing and sent by prepaid certified mail or by courier. Because the developer had not provided neither the notice nor opportunity to cure expressly required under the agreement, it could not demonstrate breach. In reaching this conclusion, the court also considered and rejected the developer's argument that it had provided the requisite notice through its conduct in litigation. The developer contended that its efforts to stop the county in the litigation on the basis of the agreement manifestly provided notice of the county's breach of the agreement. The court disagreed, finding that the developer had failed to comply with the strict terms of notice provision, as the term breach appeared nowhere in the developer's opposition papers. Ultimately, the court summarized, because the agreement unambiguously provides the county shall be deemed in breach of the agreement only upon its failure to perform any obligation under the agreement after receipt of written notice of breach and failure to cure the breach within 30 days, the trial court erred in ruling the county breached the agreement, and the developer was therefore entitled to recover attorney fees under the agreement. The same conclusion applies here. The ALA expressly defines company breach as arising only where Lively first notifies It Ends With Us movie of the alleged breach and provides 30 days from receipt of the notice to cure. This unambiguous language means that there can be no finding a breach, a necessary element of Lively's case, unless she first establishes compliance with the notice and cure provision. Because it is Lively who bears the burden of demonstrating Ends With Us movie breach, It Ends With Us movie did not need to specifically identify the notice and cure provision as an affirmative defense in its answer. It therefore did not waive reliance on the provision by failing to do so. To be sure, the plaintiff need not always plead and prove compliance with a notice and cure provision. It depends on the terms of the relevant agreement. If the agreement were to provide only that the plaintiff could not initiate suit until it provided notice and an opportunity to cure, notice and cure could be a condition to bringing suit, but not a prerequisite to showing breach. Okay, long thing here, a bunch of citations. But to reiterate, such an agreement is not an issue here. As the ALA required notice of an alleged breach and expressly states that no act shall constitute an event of default or breach absent compliance with the notice and cure provision. Accordingly, the provision of notice and cure does not go directly to whether Lively can establish breach as an element of her prima facie case. Am I saying that? Prima facie case. The relevant states' laws also matter. Sorry. The relevant states' laws also matter. This court has previously explained that under the federal rules of civil procedure, whether a plaintiff or a defendant bears the burden of pleading satisfaction of a notice and cure provision is determined by the elements of state law. As elucidated in Silverado, California law requires plaintiffs to establish compliance with clear and unambiguous notice and cure provisions where the provisions define breach around notice and cure principles. Other states might allocate the burden differently. The court therefore turns to whether Lively satisfied the notice and cure provision in the ALA. She did not. In her summary judgment papers, she points to no notice that she sent and addressed It Ends With Us movie, which specifically raised the specter of breach of the ALA. The November 9th, 2023 email sharing the protections for return to production made no mention of breach of any agreement, which makes sense given the ALA had not been executed and the offer letter contained no term regarding SH or retaliation. The December 20th, 2024 cease and desist letter was not addressed to It Ends With Us movie and therefore plainly failed to comply with the ALA's specified notice procedures, which required a writing addressed to It Ends With Us movie under the attention of Jamie Heath, setting forth the specific alleged breach. Lively did amend her CRD complaint on December 30th, 2024 to namely It Ends With Us movie, but simply amending her complaint again failed to comply strictly with the ALA notice procedures. We're on page 44. Hey, AC, how are you doing? Oh my God, I feel like it's been forever since we've seen you. Vague says you're doing amazing, only 300 more pages. Rosewild says, you know what's interesting about this timing? Blake dropped her CRD and New York Times article at Christmas, and this is coming out with Good Friday tomorrow and Easter weekend. It is interesting. It's like some sort of biblical, like mirroring or something. I need to watch all the YouTube videos to catch up. I know nothing has been happening. Well, wait, but now something's this is crazy. Did you see what happened today with all this? Lori Jane made it home. I'm so glad you made it home safely. All right. Good night, Jungle Vet Jill. Have a fabulous night. Yes, DFJ, that is what I was getting at. It's reference to the Bible and Jesus. It is very interesting, all of it. Okay. I'll just keep reading. Oh, you're starting with me? Well, who wants to tell AC? Who wants to give a quick summary? Basically, Judge Lyman dismissed all but 3 claims. So Lively had 13 claims that were left, and he dismissed 10 of them. So now there's only 3 left, and she looks like a moron. There was a hearing today that we actually could not hear. It turns out it was just about some dates, which we talked about that filing early on in the stream. And so now we're just reading for those who wanted just, to read this document like without that much commentary, although I have stopped several times to do commentary. I'm just reading it for those who like having it read to them, basically. And that's pretty much it. Yeah, it's amazing. It's like, I don't know. I'm just so happy to be celebrating with all of you. And yeah, CJ did a stream earlier too today about it. I know and then Lauren and Omar are going to be going on in a little bit. And I think most people will probably head there. I'm just going to keep going until like no one's left here. I have 12 people. So, yeah, I don't think I'm taking away from anyone or anything. So I'm just going to keep going. But I'm going to have a quick sip of tea really quick. Hold on. Okay. Lively also initiated this suit. And by the way, AC, this is a 152-page filing. And we're on page 44. Lively also initiated this suit the very next day, depriving It Ends With Us movie of its 30-day opportunity to cure. Lively suggested that any issues regarding the cure window are now moot because her first and second amended complaints were filed more than 30 days after the suit was initially filed and therefore 30 days after It Ends With Us movie had notice. But Lively's amended complaints simply allege the same breach of contract claim alleged in her initial complaint. Courts have repeatedly explained that the purpose of notice and cure provisions is to provide the breaching party an opportunity to cure the breach before litigation or termination of that contract. Okay. As the Ninth Circuit has explained, this purpose was to be completely this purpose would be completely undermined if it could be satisfied with the giving of post-suit notice. Okay. In sum, Lively has failed to raise a triable issue regarding It Ends With Us movie's breach under the relevant contractual language given her noncompliance with the ALA's notice and cure provision. Summary judgment is therefore warranted on this claim for an additional reason. The CRA is enforceable. Uh-oh. This is the part that I really don't want to read, right? The CRA is enforceable. Lively's attempts to enforce the CRA, and in particular, its provision specifying that there shall be no retaliation of any kind against artists for raising concerns about the conduct described in this letter, stand on firmer ground. The It Ends With Us movie makes two primary arguments why Lively cannot enforce the CRA. It argues that the CRA was not binding because it made reference to the ALA and thus had no force prior to the ALA's adoption. Second, It Ends With Us movie argues that the CRA was not supported by consideration. Neither argument has merit. The court starts with It Ends With Us movie's argument regarding consideration. In one of the bedrock elements of contract formation, in addition, the manifestation of mutual assent is the exchange of bargained for consideration. Consideration is often defined as some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. It is well established that the slightest consideration is sufficient to support the most onerous obligation, and that the courts are not to inquire into the adequacy of consideration. Although courts will not second-guess the fairness of an agreement or require equivalence in the values exchanged, there must still be something of real value in the eye of the law that both parties agree to give up. If a promise is so insubstantial as to impose no obligation at all on the promiser, who says, in effect, I will if I want to, then the promise may be characterized as an illusory promise, i.e., a promise in form but not in substance, and it will not constitute consideration. A written instrument is presumptive evidence of consideration under California law, but boilerplate recitals regarding the exchange of goods and valuable consideration are not conclusive and may not overcome based on the facts and surrounding circumstances. Under California law, the presumption of consideration means that the burden of proof is on the party seeking to invalidate the agreement for lack of consideration, which may be accomplished through extrinsic evidence. New York contains no such codified presumption regarding written agreements. It is instead black letter law that the burden be of proving the existence, terms, and validity of contract rests on the party seeking to enforce it. But as under California law, the words good and valuable consideration cannot serve as consideration where the facts show that nothing good or valuable was actually given at the time the contracts were made. A promise to perform a pre-existing legal obligation cannot constitute new consideration, as such a promise is not in any sense bargained for or given in exchange for a new counter-promise. However, a party's promise to perform a legal duty that is doubtful or the subject of an honest dispute can constitute consideration.
Regardless of where the burdens of this in this case fall, there is sufficient evidence in the record to conclude that CRA was supported by valid consideration. In particular, when the parties entered into the CRA, Lively's legal duty to return to set for the second half of production was at least doubtful or subject to an honest dispute. The offer letter, the only agreement by which she was bound to perform, required her to provide exclusive principal photography services for up to 6 consecutive weeks during the run of production. Okay, her duty to continue with filming at that point on a different schedule than the one previously agreed to was therefore subject to at least some uncertainty. Her agreement to resolve that uncertainty by returning to set constituted valid consideration. That is what the CRA in fact recites. It states that the parties wish to confirm the conditions upon which Blake has agreed to cause Lively to render acting services on the film following the break in production of the film related to the 2023 WGA and SAG-AFTRA labor strikes. The clear implication is that absent agreement to the conditions, Blakel would not cause Lively to return to set. And because it was unclear whether Blakel had an obligation to cause Lively to return to set and whether Lively herself had such an obligation, the CRA was supported by valid consideration and is binding. It Ends With Us movie also argues that the CRA is not enforceable because it makes reference to the ALA and the ALA was not executed. That argument has no greater merit. The CRA states that it shall be deemed incorporated into the ALA. The CRA also states that the event of a conflict between the CRA and ALA in terms of the CRA govern. The interpretation of an unambiguous contract is a matter of court. It is clear that the CRA does not make entry into the ALA a condition precedent to the execution of the CRA or to the parties' obligations under it. As previously explained, a condition precedent is an act or event other than a lapse of time which, unless the condition is excused, must occur before a duty to perform or promise in the agreement arises. The CRA sets forth a series of promises by It Ends With Us movie, none of which is conditional upon there being an ALA, and each of which is stated to confirm the conditions upon which Lively would return to work. In context, the reference to the ALA means nothing more than that they were the ALA to be executed. The CRA would be deemed incorporated into it and not superseded by it. In other words, the CRA contemplated the possibilities of the parties would enter into the ALA, and it set forth how the CRA would apply in the event of that contingency. It was not itself contingent upon the signing of the ALA. The parties' conduct confirms that understanding as they both perform under the CRA, notwithstanding continued negotiations over the ALA. The Wayfair parties took steps to implement the CRA's requirements, including by hiring a new producer. Lively, for her part, returned to set for the second phase of production. The CRA thus carries independent and binding force. It Ends With Us movie argues that even if the CRA was enforceable, Lively's claims for breach of that agreement must be rejected. It Ends With Us movie again relies on the notice and cure provision in the ALA, but no such provision appears in the CRA. Of course, where there are multiple integrated agreements, those agreements are to be read as a unified whole. But here, there is only one agreement, the CRA, because Lively never agreed to the ALA, she cannot be deemed to be bound by its terms. Indeed, as explained above, the intent of the parties is making reference to the ALA was not to incorporate all of its terms, including conditions precedent including the conditions precedent and the notice and cure provision, but to ensure that if the ALA were ever adopted, it would not supplement or supersede the CRA. In order to uphold the validity of terms incorporated by reference, it must be clear that the parties to the agreement had knowledge of and assented to the incorporated terms. The parties did not assent to the incorporated terms and did not effect a wholesale adoption of the ALA through the back door of the CRA. Nor did they nor did they evince an intent to carry over any of the ALA's specific provisions. Incorporation by reference is ineffective to accomplish its intended purpose when the provisions to which reference is made do not have a reasonably clear and ascertainable meaning. Even if one of the parties did secretly intend for some of the draft's ALA terms to be carried over into the CRA, a proposition for which there is no evidence to support, it is entirely unclear which provisions that would include from which draft of the ALA. The parties referred to the ALA. They did not refer to a draft unexecuted ALA of a particular date. I feel like Lyman's just like kind of tongue twisting himself into trying to make something last for Lively. I don't know. What do you guys think at this point? Oh, thank you so much for the super chat. Thank you for reading words I can never pronounce. Honestly, I can barely pronounce them either. So thank you so much, AC. I appreciate you. Thank you. That means a lot to me. And for those that missed it, I'm $10,000 in the hole from the vet bill from Ozzy. So I appreciate every super chat very, 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 very much. It's going to a very good cause. So thank you. And I'm glad you're here, even though this might be boring to some people, but some people like, and I like it because when I read it out loud, then I will make sure I read it. And 152 pages is really hard to read, usually in one reading. So we're going to keep going. It Ends With Us movie also argues that Lively's claim under the CRA fails because she cannot prove damages. It Ends With Us movie makes four arguments in this respect. Lively cannot recover consequential damages, or what California law calls special damages under the limitation on damages clause in the ALA. Lively cannot recover emotional distress damages for breach of contract. Lively's alleged contract damages are improperly duplicative of her alleged statutory damages. Lively cannot recover damages for the lost profits or royalties of two entities she controls, Blake Brown Beauty and Betty B Holdings LLC, for lack of standing, and because such damages are speculative. None of these provides a basis for granting judgment on Lively's CRA claim. To begin, the Wayfair parties argue that nearly all of Lively's asserted damages are consequential or special damages, and that such damages are barred by a provision in the ALA stating that in no event will any party hereto be liable for or have any obligation to pay the other consequential and or incidental and or special and or punitive damages. The argument fails for the same reason that the notice and cure argument above fails. No analogous provision appears in the CRA. The parties never agreed to the ALA. They are both bound by it. Second, It Ends With Us movie argues that under California law, a party cannot recover damages for emotional distress, including distress from loss of reputation as a result of a breach of contract. There may be some question with respect to the reach of that doctrine and its applicability here. When the express object of the contract is the mental and emotional well-being of one of the contracting parties, the breach of the contract may give rise to damages for mental suffering or emotional distress. The court need not reach that issue, however, as Lively does not ground her opposition to summary judgment on the basis that she is solely entitled to damages for emotional distress and loss of reputation. Third, It Ends With Us movie argues that Lively's contract claim is improperly duplicative because she seeks recovery for the same damages under her statutory causes of action. The case that It Ends With Us movie cites, however, stand for the proposition that if a plaintiff proceeds on two claims, each of which seek damages for the same injury, the plaintiff will not be entitled to double recovery. Lively's statutory and contractual retaliation claims will present their separate challenges at trial. Lively need not forego one theory of recovery at this stage in order to pursue the other. Finally, It Ends With Us movie argues that Lively cannot recover for lost profits to Blake Brown Beauty and Betty B Holdings. Lively responds that she is not seeking relief in her capacity as a shareholder, but rather direct damages to her own business reputation in connection with her own legal claims. The court has the authority under Rule 56G to determine a fact that is not genuinely in dispute, including an item of damages. However, the exercise of that power is discretionary. The court can decide that if it is better to leave the matter for trial. In this case, the parties devote only a few pages to Lively's theory of damages. The issue is better addressed at trial or prior to trial through motions in limine directed to the admissibility of evidence and argument. Okay. It ends with this movie's motion for summary judgment with respect to Lively's contract claim under the CRA is denied. Okay. Lively's employment status. What do you guys think about this one? About his arguing for that? Let me see. He did, okay, Rose Wild says, Lyman says in some spots she has no claims, and in other parts that her claims have merit and are far from baseless, and a reasonable jury could see SH and smear campaign and other things. What? Lyman smears Wayfair in this. Oh, okay. Let me start with this comment. Sorry, I missed it. Okay. Lyman smears Wayfair. Roses Wild says Lyman smears Wayfair in this, including in footnotes where he says that when Blake told Heath she knows he wasn't trying to cop a look, that she was diffusing tension, not because she did not think that there was SH. Good call, Roses Wild. I agree with your assessment of that. I agree with that. And then Lyman says in some spots she has no claims, and in other parts that her claims have merit and are far from baseless, and a reasonable jury could see SH and smear campaign and other things because Lyman just can't help himself. And that's the thing I want people to realize, because some people are praising him today. I was like, no. Check yourself. This is Lyman. This is Judge Lyman. He basically put his foot on the scale at the very beginning of this by improperly dismissing Wayfair's lawsuit, and he just kept his foot on the scale the entire time, and he was always like going at it with Brian Freeman. He did not hide his biases. AC says, Rose, really? To be honest, I still don't like Lyman, but he knows her case is shit. He did say this, AC, then dismisses her case on a technicality. So okay, so all those like the Blake stans that are saying that, or I should call them simps. They're not even stans. They're like, they literally are simping for her, probably because they're paid to, in my opinion. But let's just say that they're doing it because they actually believe something. So are you saying that they are right when they're saying that this was dismissed on a technicality? Because I don't think it was only dismissed on a technicality. Roses Wild says, I felt like he needed to give her a win. So in parts where it would affect his brother's work, he says that no one did wrong. In other parts, he claims that there was SH and smear campaign. And so for those who somehow don't know, his brother is a producer or director. I don't even know, but he's in the industry. So he can't say things that would, screw up the rest of the movie industry, because he's kind of invested in it, which is also why he should have probably dismissed himself. He probably should have removed himself from this case in the very beginning. Vague says, in all honesty, it's irrelevant. Who cares what smoke he's trying to blow up their ass? It's irrelevant. True, but he's once again doing the lawyering for Lively. I mean, in his own order, he's trying to like give her PR talking points, and that's what's like bothers me. So he basically argues for her and then says he's dismissing on a technicality. I agree. Yes, and Leanne said this also in her video. Trish says, I heard the word simping for the first time yesterday, and now the second time. Were they both from me? Yeah. I mean, I don't know how else to describe her fans, like paid trolls, maybe. I messed up my message above. Sorry. Call service is bad. 40 more miles. Don't worry, girl. We got you. Lori Jane says he gave Blake an out because he knew she was going to look like a fool in court. That's a good theory, Lori Jane. I like that. So he basically just helped her out. AC says, does this mean she will reappeal? Oh, she'll probably appeal. Probably. I'm guessing she will. I'm going to need to refill my cup soon. Should we keep going? Uh-oh, did Lauren start? Let me see. I'll check. I don't want to keep you guys from her. You're more than welcome to go there. Oh, she starts. Okay, so she starts like another 20 minutes. All right, let me go back here. StreamYard. Michelle says, I still think Lyman is biased regardless of decisions made now. I'm with you. I'm with you, girl. 1,000%. I really think he is biased. He's been biased this whole time. And I think if he did anything, it's because he felt forced to. Oh my gosh, Khaleesi, when did I miss your super chat? Wow, thank you, DFJ. Team Truth. Yay, thank you so much. Just Khaleesi, you are an amazing mod and you always are so, again, I always appreciate your support and for this channel and for everything. And I'm so, you did not have to do that because you always already do so much. So I really appreciate that. Thank you. That makes me so happy. That makes my day. We're celebrating Team Truth. That's so awesome. Thank you. Love you. Oh, thank you. I love you too. Okay, so we're gonna keep. Oh, what did you say about Van Zandt? Roses Wild said, I wonder if she appeals, if that opens discovery. If it opens discovery, Van Zandt can be used against Blake and not just Stephanie Jones because it happened after discovery on Blake's case, so they couldn't use it in Blake's case, but it can if discovery opens again, I believe. Well, that's an interesting, that's very interesting. Yeah. Yes. Thank you, Vague. Yeah. We love Khaleesi. So, Kenny says you think Lauren starts in like 5 to 6 minutes. Okay. Well, what do you guys want? Do you want me to just keep going? Do you want me to forward you there and stop here and then pick up in like a different stream? You tell me. Let me see what my chat says. Oh, we love you too, Khaleesi. Thank you. You sent money? Oh my gosh, wait, I didn't see that. Sorry if I missed it, Lori Jane. I sent a little money, not a lot. Love you. Well, thank you, Lori Jane. I appreciate you too. Thank you. And I've seen you give super chats before. You do you, DFJ. Well, I mean, you tell me. She's scheduled at 10:45, I think, but she's usually a few minutes late. Oh, you're talking about the 10K. Yeah, well, that was crazy. That's how much the vet bill was. Well, it was $9,300 to be honest. So maybe I should say 9,000. That's how much his vet bill was. But it was so worth it because he's here. And he's alive and he's being so cute. Okay, we're gonna keep going then. I'm gonna refresh really quick. What do you guys want to do? You tell me. Don't tell me to do me. Maybe I should just send you all there. Okay. Maybe that's what I'll do. And then I could do like a part 2 reading of this or something if you guys want. Vague says, stick around. I have 39 more miles in me. I think I'm going to send you guys to her. It will be good. LOL, keep going until she starts. All right. Well, are you going to tell me when she starts? Are you guys going to give me the bat signal and then I can send you there? You tell me. Trish says, I'm surprised they charged you after hearing he fought off 3 coyotes. I know. Well, and I felt like they were such a great vet. And honestly, I would have been okay with maybe half that. I'm just like, oh my God. But, you have to do what you have to do. It's, I don't know, maybe what is the right word? Are we in a recession or something or in inflation? But he's going to be worth it. I'm just going to have to make some changes and work a little bit harder. And I'm sure everything will be okay at the end of the day. Oh, you get notifications when she does. Okay, so should we read Lively's employment status? Yeah, all right. Lively's employment status. Lively's first and second causes of action allege harassment and retaliation in violation of Title VII of the Civil Rights Act of 1964. Her fifth cause of action alleges retaliation in violation of California Labor Code Section 110.2.5. The Wayfarer parties raised the threshold issue of whether the laws cover Lively in the first place. Under both California and federal law, the question whether an individual worker should properly be classified as an employee or instead as an independent contractor has considerable significance for workers, businesses, and the public generally. California Labor Code Section 1102.5 similarly requires the plaintiff to prove employment status. Lively's SH and retaliation claims under these provisions can therefore proceed only if she was an employee rather than an independent contractor. The court will assess Lively's employment status under Title VII and California Labor Code Section 1102.5 in turn. Title VII. Keep going. Okay. Yes, please. Okay, I'm going to keep going. I do have to refill this really quick, though. I'm so sorry. Is that okay? Hold on one. Yes, hydrate. We are back. Okay. We're going to keep going. Title VII, legal background. Title VII covers employees, but the statute's definition of the term circular, the act states only that an employee is an individual employed by an employer. In determining whether a person is an employee for the purpose of Title VII, courts have applied the analysis derived from the Supreme Court's decision in Community for Creative Nonviolence versus Reed, 1989, a case involving the Copyright Act, and Nationwide Mutual Insurance Company versus Darden, 1992, a case involving the Employee Retirement Income Security Act, C. O'Connor. And then it says Salomon versus Our Lady of Victory Hospital, 2008. The relevant factors are drawn from the general common law of agency rather than from any particular state's laws, given that federal statutes are generally intended to have uniform nationwide application. In particular, the Supreme Court has outlined 13 factors drawn from the restatement of agency and from case law that courts are to consider in determining whether a person is an employee. In determining whether a hired party is an employee under the general common law of agency, we consider the hiring party's right to control the manner and means by which the product is accomplished, among the other factors relevant to this inquiry. Okay. Into this inquiry. Are the skilled required? The source of instrumentalities and tools, the location of the work, the duration of the relationship between the parties, whether the hiring party has a right to assign additional projects to the hired party, the extent of the hired party's discretion over when and how long to work, the method of payment, the hired party's role in hiring and paying assistance, whether the work is part of the regular business of hiring, whether the hiring party is in business, the provision of employee benefits, and tax treatment of the hired party. Balancing the Reed factors is a highly fair-specific task that should not be performed in a mechanistic fashion. No one factor is dispositive, and additional circumstances may be considered if they are drawn from the common law of agency that Reed seeks to synthesize. Court must disregard these factors that, in light of the facts of a particular case, are 1, irrelevant, or 2, indeterminate weight, that is, those factors that are essentially an equipoise and thus do not meaningfully cut in favor of either the conclusion that the worker is an employee or the conclusion that he or she is an independent contractor. A court may determine that a plaintiff is an independent contractor even if one or more of the Reed factors analyzed in isolation would suggest the contrary. The analysis is not indifferent to congressional intent. A person who may be deemed an independent contractor for purposes of the work for hire provision of the Copyright Act, where the rights to intellectual property can depend on contractual terms, may nonetheless be an employee for purposes of Title VII, where Congress intended to create public law rights that were vested in workers as a class and not subject to waiver or sale by individuals. Thus, while factors such as employment benefit and tax treatment might deserve special consideration in the copyright work for hire context where workers and employers are free to allocate intellectual property rights by contract, those factors are entitled to less weight in the employment discrimination context, as firms could use individual employment contracts to opt out of the anti-discrimination statutes. As the Second Circuit explained in Eisenberg, the core substantive protections of the anti-discrimination laws were not intended to be skirted by the terms of individual employment contracts. The most important factor in determining the existence of an employment relation contract under Title VII is the control by employer, which characterizes the relation of employer and employee and differentiates the employee or servant from the independent contractor. The degree of employer control is the foundation for Title VII's limits. Independent contractors are thought not to need Title VII protection because such contractors already have a degree of control over their employment. The presence or absence of each Reed factor raises a question of fact, but the ultimate determination as to whether a worker is an employee or independent contractor, that is, the balancing of the Reed factors, is a question of law. If based on the undisputed facts, no reasonable jury could determine that the plaintiff was an employee, the court may not shirk from stating that conclusion. Restatement, second of agency. If the inference is clear that there is or is not a master and servant relation, a master and servant relation, the determination is made by the court. Otherwise, the jury determines the question after instruction by the court as to the matters of fact to be considered. Okay. Case law. Okay, factual background. The parties dispute the existence of certain Reed factors and the extent to which they either weigh in favor or against a finding of employment status. However, they did not dispute the underlying material facts. Lively agreed with It Ends With Us movie, a company formed to produce a single film, that she would perform a specified role in the film based upon a pre-agreed script with a pre-agreed director and a pre-agreed co-lead. The offer letter between It Ends With Us movie and Lively's loan entity, pursuant to which Lively performed and was bound, see Supra, gave Lively important rights both with respect to the film and her participation in it. No change could be made to the script, the director, the co-lead, or the double, if any, for Lively without permission. Lively had rights with respect to her hair and makeup. Section 8 of the agreement is titled Approvals and states, artists will have mutual approval rights over the following: hair, Ann Carroll approved; makeup, Vienne Barker pre-approved; and wardrobe personnel, stand-in, stunt double, if any, B, the screenplay, C, director, with Justin Baldoni pre-approved, and any replacement, and D, the co-lead for the picture with Justin Baldoni pre-approved, and any replacement thereafter. Meaningful consultation over the look of the role, ad campaign, and release pattern. Hair and makeup personnel are exclusive to artists. Peter Owen is pre-approved as wig maker. That was a wig. She paid for that hair? I thought she just had some squirrels run through it or something. Like, her hair was crazy looking. Oh, Tiffany, hi. I'm finally home now so I can watch DFJ and Bochi at the same time. I'm just reading the rest of this document for those that wanted to read it. I kind of started out a little crazy, just giving my opinion. Now we are just reading. It was good to see you. Tonight is giving my flashbacks. Everyone is live. I know it is. It's like this is like kind of like a mini Super Bowl, right? A little bit. Yeah, we're almost done. We are. Oh, nice. You're still alive. Hey, Pam. Good to see you. Pam's following you around, Khaleesi. You know where all the things are happening, all the good stuff. Corals. Yeah. Also, I think. So, who approved your thin piece of fabric in the birthing scene? Blake Lively. Good call, Trish. Right? And according to the PGA letter, she was in charge of everything. So, like, why are we here? It's so stupid. Oh my God. Okay. Moving on. The offer letter contained additional approval provisions, including Lively's right to sign off on the film's start date in May 2023, any shoot dates outside of New Jersey or New York, her transportation for such shoots, the trailer provided for her on set, use of her name, voice, or likeness in merchandise, commercial tie-ins, co-promotions, and the like, outtakes and behind-the-scenes shooting, and the use of any such footage, press and EPK crew on set, interviews, press releases and statements, use of nudity and or simulated scene in the film, and digitized or doubling of Lively in any such scene, doubling of Lively in the film more generally, and use of clips from the film. There is no genuine dispute that Lively's approval rights were honored in practice. Lively's counsel acknowledged at oral argument that there was nothing in the record indicating that the Wayfair parties ever ignored, refused, or rejected Lively's exercise of her approval rights under the offer letter. There's a footnote here. The court has found that the ALA was never an executed or binding agreement. It has also found that the parties performed under the offer letter. The court will accordingly look to the offer letter in ascertaining the nature of the parties' working relationship. Okay. Page 59. That's 59. There also is no genuine dispute that Lively had extensive involvement in and control over many of the decisions related to the film and her role. She does not dispute the underlying facts relayed in her letter to the Producers Guild of America, the PGA letter. As reflected in the letter, Lively, okay, let's see what he says. Lively led the location shift from Boston to New Jersey and helped to solve all cost and schedule logistics associated. Personally called and or wrote emails to crew and put forth names for department head roles and identified and onboarded freelance team members for the cast members, reviewed and reshaped the creative of the production design for all key locations for all characters, reviewed and reshaped the creative of the costume design for all characters. See, she was in charge of wardrobe, costume design. Went through hundreds of casting tapes to help find the rest of the cast, including our stars Atlas, Young Lily, Young Atlas, and Jenny Bloom. Zoomed with every cast member to get their notes and ideas and did significant rewrites of the script to incorporate all the notes of the cast, studio, distributor, author, director, all while addressing scheduling, financial, location, weather, and or logistical constraints in that rewrite. Unfortunately, was responsible for the firing of our first AD, Julie, as we were not making our days for the first many weeks. These are all in quotes, by the way. Helped to block the staging of every scene for shooting efficiency, reviewed and instated COVID protocols, managed the politics and HR concerns on a daily basis, acting as an intermediary to crew and cast, engaged safe and on board, was the director's partner in all creative and logistic concerns. Wow, doesn't it seem like she ran that movie? Oh, we have a footnote here. Lively does dispute the suggestion that she unilaterally caused the assistant director to be terminated, stating that it was instead done on producer Alex Sachs' recommendation due to performance deficiencies. The difference is immaterial to the disposition of these motions. And we're going on. He's giving more examples from that PGA letter that completely tanks her case. Watch the monitor between every take to be sure everything that ended up on screen from every department was best servicing the film and lead the changes needed to get there where applicable. led the hiring of a freelance producer to help balance the set and the hiring of a new intimacy coordinator and intimacy doubles to help block out the sensitive scenes for both safety and shooting efficiency, called and led meetings with all department heads, the studio, and distributor when we had extenuating circumstances challenging our production plan, and acted as a liaison between cast and the reps in finding solutions to finishing the film. Worked with the film's original editor to be sure the director's goal and preferences for the film were understood and honored before starting with my own editors to expand the audience and commerciality of the film. Worked with her, quote, own editors May 2nd onward, running a room of sometimes 3 editors at once as we pushed to meet the timing for 3 test screenings and eventually picture lock. Brought on a new composer after personally reaching out to him and convincing him to join us with very limited time, troubleshooting financials and logistic hurdles to get him on board. Hand selected 90% of the songs in the film. I wonder which 1% she didn't select. Worked on the visual effects, overseeing every shot that makes it into the film, solicited and implemented feedback based on test screening, worked closely with the international teams on everything from posters, commercials, book covers, and beyond by territory, and with the digital team on everything from the social media pages down to the color palette, graphics, language, copy, cadence, and even what font it was used in, when and how. Worked with the cast representatives, producers, showrunners, tour managers, spouses. Remember that? The spouses. She worked with people's spouses. CJ said, hide your wife, hide your spouses. Hide your kids, hide your spouses. Travel agents and beyond to coordinate their schedules for press, going as far as successfully begging their bosses to release them for press for our film. And remember, at that time, who was like young Lily's boss was like a restaurant manager. Okay. There also is no dispute that in addition to a flat sum guaranteed as payment for her work on the film, Lively was entitled to contingent compensation based on the film's performance, as well as compensation in the form of credit and bonuses for awards. The offer letter committed Lively to providing 6 weeks of exclusive principal photography services plus standard prep services subject to her approval and availability, and up to 3 free post days. At any other point, Lively was free to accept other work and to perform in other films, which she did. The PGA letter indicates that she was shooting another film while simultaneously working a minimum of 10 hours a day on post-production for the film. As for her working hours during principal photography, the offer letter cabined them as followed: 12-hour portal to portal, i.e. drop off at home until pick up at home the following day, turnaround if artist stays in Manhattan, 10.5-hour portal to portal, drop off at home, pick up at home the following day, turnaround if artist stays at upstate residence, 56-hour portal to portal, drop off at home at the end of the week until pick up at home the following workday. Weekend workaround, provided that artists will give good faith consideration to reducing the weekend turnaround to 52 hours portal to portal, up to 2 times during principal photography, 12-hour cap on days, calculated from when the car drops artists off at base camp at the beginning of the day until artist gets back to the car at base camp at the end of the day. 5 days a week, Monday through Friday, no more than 1 forced call without artist prior consent. Analysis. The undisputed facts reveal that Lively enjoyed a degree of economic independence sufficient to make her an independent contractor. Although not every factor weighs equally in favor that that conclusion when viewed in isolation, analyzing the factors collectively eliminates any genuine dispute. That means that Lively cannot bring claim under Title VII. The court first analyzes each read factor separately, recognizing that they overlap and that certain undisputed facts that are relevant to one factor may also be relevant to others. Right to control. This factor favors independent contractor status. Lively enjoyed extensive control over the means and manner by which the product was produced, both as a matter of contract and in practice. The type of comprehensive control that characterizes a traditional employer-employee relationship was absent here. By contract, it ends with this movie could produce only one product with Lively's participation, the film, for which her approval of the script director and co-lead was required before she was bound. Moreover, It Ends With Us movie could not make any changes to those aspects of the production without her approval. She had the right to meaningfully consultation, not just the look. Sorry, she had the right. See, I think that's a typo there. She had the right to meaningfully consultation, not just over the look of her role, but also over the ad campaign and release pattern. Her name, voice, or likeness could not be used in merchandise, commercial tie-ins, co-promotion, soundtrack, novelizations, publications, and/or connection with advertising or promotion of a theme park or a theme park attraction without her prior written consent. At 3, she had the right to approve any behind-the-scenes shooting and any use of footage, any outtakes, the press and crew on set, and any interviews. It Ends With Us movie could not issue a first press release mentioning her as an actor without her approval and could not issue any additional press releases mentioning her other than as an actor in the film without her approval. She had control over her hair and makeup, and the Wayfarer parties did not have the right to cast an actor as her double without her prior consent. Lively also had power as a matter of the day-to-day reality of the parties' working relationship. Lively described Baldoni in the PGA letter not as an employer, boss, or superior, but as a partner in all creative and logistical concerns. Her declaration. It is undisputed that, among other things, she reviewed and reshaped the production and costume design for all key locations and characters, performed significant rewrites of the script to incorporate feedback from the cast, studio, distributor, author, director, received in stated COVID-19 protocols, led meetings with all department heads, the studio, and the distributor, oversaw a team of editors, and coordinated and managed cast and crew's various schedules for the film's press release. Lively emphasizes that the Wayfarer parties had no right to control her performance because she had to render her acting services when and where they directed. Specifically, she states that she had to adhere to a set work schedule and provide exclusive services during filming. But these factors weigh only marginally, if at all, in favor of her being an employee. The duration of her work on the film and the start date on which the work began were heavily negotiated. Just as she was required to start in May 2023 and to continue for up to 6 consecutive weeks during the run of production, so too, if It Ends With Us movies wanted to make the film with her, was It Ends With Us movie required to adhere to that schedule. Moreover, that Lively's time commitment was defined by the task at hand, the run of production, with a maximum number of weeks during which she could be required to work, further suggests that she was not an employee. Lively was hired only for a particular role. It Ends With Us movie could not assign Lively other projects. It had no right to any of her time beyond what was necessary to accomplish that project and what was outlined in the offer letter. Lively, not It Ends With Us movie, would have the choice of whether to contribute the additional hours. It appears to be true and must be taken as true for purposes of this motion that once the parties agreed that shooting would start in May, Lively had no discretion but to devote up to 6 consecutive weeks to the film until production was complete, and that during that period, she could not offer principal photography services to anyone else. However, that cannot be enough to make her an employee. A movie cannot be produced without the simultaneous participation of a number of persons, including the director, cast, and crew. Thus, even assuming that plaintiff was expected to work a particular schedule, it is in the very nature of plaintiff's work that obliged her to work on certain days and at certain times. The fact that an independent contractor is required to be at a job at certain times does not eliminate her status as an independent contractor, quoting Browning versus Siva Freight LLC. Okay. An opera performer may have limited dates on which she can perform and must make sure that the dates she chooses are ones on which the conductor and other performers will be available. But that does not mean that because her performance is dependent on the participation of others, she is by necessity an employee. For similar reasons, the fact that Lively could not, during those 6-week, participate in principal photography for anyone else also does not make her an employee. Depending on the circumstances, an inability to take on other work can support a finding of an employer-employee relationship. That is because the freedom to accept other work from other sources lies at the very heart of independence inherent to independent contractors. In context here, however, the requirement that while principal photography took place, Lively's acting services would be exclusive to It Ends With Us movie does not reflect that she lacked the economic independence to be an independent contractor. The contract reflected nothing more than Lively's commitment of the time necessary to film her scene alongside other actors and the film's crew. At any other point, she was free to accept additional work and perform in other films, and she did so. The PGA letter indicates that she was, quote, shooting another film while working on post-production for the film. Okay, so you guys, I think, let me check in. Is Lauren on? Your tea has been made. Decided not to go to the computer, staying on the phone. The size of Ryan's head, Kenny says, the size of Ryan's head is directly related to the size of his ego. I love you guys. You guys are so funny. Yes, the PGA letter. I am so happy that if he did not was to read anything, if he was to read anything that she submitted, I'm so glad he read the PGA letter. All right, she is on. So you guys, I just, I want to support her. I am one of her mods. So I think that maybe I should, let me go into my channel and let me forward us there. And we got through a lot of it. 65. I mean, there's still 90 pages left. But I think we got through a lot. And yeah, maybe I'll do more on I don't know, in another video, or hopefully someone else will pick it up from there or something. But yeah, let's go see Lauren. So I just need to, what I have to do is I have to just go into my settings and customize, redirect. Okay, court random opinion. I wonder if I have to save it. It's not letting me save it. Well, I think that should work. So I just want to make sure. Yeah, it says I can redirect. Okay, so we're going to go there. I love you guys. I'm going to see you there. Thank you to my mods so much. You guys are such rock stars. Today's been a crazy day. And yay, let's go celebrate over there. All right, you guys, I will talk to you soon.